That may be called. Item number 31.
What is regarding what?
One second. Number 19 of pages. Matter may be addressed for the day in this matter considered file one affidavit.
Okay, right.
Will file our decline.
Miss, huh? You Nanda learn counsel for the petitioner submits that the petitioner would like to file a reply affidavit to the affidavit filed by the respondent. As allowed, list the matter after.
Next week of any day on Thursday.
When will you file your affidavit?
Yes.
When will you file?
File this week. Friday.
Friday is tomorrow. You see, they don't ask for dates when you're not going to keep, you're not going to be ready for it. When?
What you want 10?
List the matter on 10th. New matter, old matter. New matter. Okay. You have to give your memo. Yes.
May I please, your lordship? Lordship, I beg to mention item number 9.
Yes.
We have taken consent from the other side, lordship. And we have
Yes.
filed our affidavit yesterday, lordship.
Okay.
9.
Who's for the petitioner?
N. Sekya.
Okay. What is your name?
N. Kalita.
Mr. N. Kalita, appearing for
Industries and Commerce Department.
Industries and the Commerce Department submits that affidavit of position has been filed yesterday
Yes, lordship.
and
Additional affidavit.
additional affidavit has been filed yesterday.
Yes.
And accordingly prays that the matter may be adjourned for
1 week, lordship.
full stop for 1 week. Huh? He also submits that he has taken the consent of the petitioners. Perfect. List the matter after a week.
Obliged.
Huh?
And neutral party to market option.
Item?
Not item.
New matter.
It's for withdrawal. Why not there for this? Why not this matter relating to contract admitted contract?
The admitted contractor. Old matter, new matter? Huh? Old matter.
Like. Lordship, item number 11. It's the consent of the respondent.
Okay.
So we taken about 2 weeks. So we are waiting some decision.
What is to be done out here? Our pleadings are complete or not?
Meetings are
Almost are complete.
my IMFL onshore license was suspended. This honorable court interfered and kept that suspension in abeyance. In the meantime, I was offered an option to go for a shifting of the premises. I moved the application. That application reports have come, the government is looking into it. If the shifting comes, my lord, we need not pursue this application. In case they reject it, then perhaps we need to pursue it. So therefore, my lord, around 2 weeks time will be required by.
Okay, Mr. R. Majumdar, learned counsel for the petitioner, prays for adjournment and submits that he has taken the consent of the other side. List the matter after 2 weeks. In order to continue till the next week.
Okay. I think 126 permission.
Huh?
51 of the whether using autonomous council the power that they along there is they don't have any power.
Not 51.
51 is, lordship.
Huh?
Yes, 51 is relevant, lordship. Very much relevant.
51 says,
20.
51 says in general counsel, okay, so that's enough.
That's enough. They have asked for government fisheries.
Actually, this, huh?
They have asked for government fisheries, but they are being restrained from doing anything in any national body.
Naturally, then now, so what remains now? You can go in appeal.
How about I
I tell them to produce the and give the so that we'll dismiss it straight away. We cannot allow it now. It will come production list. Make a production list. Right.
Regarding event with the missing of must come regarding challenging of that notification of the role challenging of the
That is okay, right. Okay, this part one, this item one. Who is in item one? You are in item one. This is with regard to challenging the NIT.
By giving a direction to the state government to settle the fishery as soon as possible. By issuing fresh NIT. Now, that process was not initiated. So, in between, the people representing the MSC had given settlement of the same fishery to the private respondent.
Correct.
So, the facts are a little different because no existing.
You see, at the end of the day, that early direction passed in the earlier writ petition has attained finality. So that does not need to be, that is not required to be mentioned here, here again.
Not required.
They're not required. Now it's only with regard to the settlement made. Correct.
3, 4, and 5. In 3, 4, and 5, we are challenging a settlement order. In which cases,
2, 3, 4, and 5.
I am representing Malawi.
Settlement order given to the private respondent by the MAC on the basis of a NIT. No NIT. No NIT. So in the first one, there were, what are you challenging in the first one? Second one also settlement order.
Yes. Difference is that in second, third, and fourth, and fifth, already I am the existing SC.
Okay.
Already existing SC.
In the first one, you're not the existing lesbian. Okay.
I have something to say in respect to this is ABC, no? This is ABC. This item number
There's another point, Manoj.
Yeah.
Item number
3, Lordship. It is I have a point, Lordship.
In items?
Item number 3, Lordship.
Yes.
Here, though these things, he has not actually we have verified the record. He has not paid any amount.
that is a different issue,
Yes,
Manoj.
That is a different issue. That is for MAC.
Yes.
That is not, this is not your case.
Right now, while
That is a different cause of action.
while
Yes, Mr. TJ Mahanta, you're in NIT. Acha, NIT. But you're not the settlement holder or anything like that. Okay. Okay, right. Heard Mr. H. Buragohain, Learned Counsel for the petitioners in serial number 1 to 5. And Mr. T.J. Mahanta, Learned Senior Counsel for the petitioners in WPC 3971/2024, assisted by Ms. R.M. Barwa. Mr. P. Sharma appears for the
Fishery Department as well.
Fishery Department as well as the Assam Fishery Development Corporation. Mr. appears for the that volume has become very low. Missing autonomous counsel. Anyway, happens part of your lawyer education. Also had Mr. R. Dhar, Learned Counsel for the private respondent in 1, 2, 3, and 4. Okay. Ms. U. Das appears for the district commissioners of the various concerned districts. Right. The issues raised in the writ petitions is with regard to whether the missing autonomous council has the authority to settle any fishery or natural water bodies within the area of the missing autonomous council. Full stop. As such, the further issue that crops up is whether a missing autonomous council could have issued any notice inviting tender for settlement of any fishery or natural water body within the area of the MAC. Huh? So hereinafter referred to as the MAC. Okay. In serial number one, WPC, serial number one, the petitioners are aggrieved with the settlement order made by the MAC in favor of the made by the MAC for settlement order of a fishery made by the MAC in favor of the private respondents without issuance of an NIT. Full stop. In WPC, the 2 to 5, the petitioners are aggrieved with the settlement of the fishery by the MAC with private respondents, even though there is an existing lessee of the said fishery, the settlement of which has been made by the fishery department, government of Assam, and slash or the Assam Fishery Development Corporation, bracket AFDC. In serial number 6, the petitioners are agreed with the issuance of the NIT by the MAC for settlement of fisheries located within the MAC area. The counsels for the petitioners submit that the said issues have already been decided by a coordinate bench of this court in a batch of writ petitions, the lead case being WPC 3065/2024. Full stop. Next para. No, continue. They accordingly submit that the present writ petition can be disposed of in line with the judgment and order dated 20/08/2024, passed in WPC 3065/2024. Full stop. Next para. The counsels for the respondent also submit that the present case is the present batch of cases is a covered case.
Yes.
In terms of the judgment and order dated 20/08/24, passed in WPC 3065/2024. I have heard the learned counsel for the parties. A perusal of the judgment and order dated 20/08/2024, passed by a coordinate bench of this court in WPC 3065/2024, shows that the present batch of writ petition is covered by the above judgment. On perusal of the judgment and order passed in WPC 3065/2024, I do not find any grounds to disagree with the decisions taken by the coordinator. Wherein it has been held that neither the General Council or the Village Council of the MAC has the authority to settle any fishery or even natural water bodies as exemplified in the notification dated 7/3/2017 issued by the issued in the name of the governor by the Principal Secretary to the Government of Assam, Fishery Department. Pusta. Next para 39. Which are the paras? Para 39 to para 39, 40.
Para 40 is also relevant.
Huh?
Para 40 is also relevant.
That's what I said. 39, 40.
Yes.
I think 44.
Yes, 44 is. Yes, 44.
43 is not required, no?
44 is required.
44. Huh?
44 is very relevant.
44. 39, 40, 44.
Yes.
45.
47 is also relevant. 47 is also relevant.
47.
48 is a very clear, Lordship. The question therefore arises as to whether in such a
48.
51 to accept.
50 and 51 are reproduced here in below as follows. As this court does not find any grounds to come to a different finding with respect to the issues raised in the present batch of writ petition vis-a-vis the judgment passed by the coordinate bench in WPC 3065/2024. This court finds that the general council or the village council of the MAC does not have the authority to settle any fishery or natural water bodies as per the notification dated 7/3/2017. Accordingly, the very issuance of NIT for settlement of the said fisheries within the area of the MAC is also beyond the competence of the MAC. The writ petitions are accordingly allowed. That's all. Anything to be done? The settlement of the fisheries made in favor of the private respondents in serial number 1 to 5 are hereby set aside. How do I want the date? Where's required? Settlement. Further, the issuance of the NIT dated
24, 5/6/2024.
5/6/2024 for settlement of the fisheries within the MAC area by the MAC is also set aside. The writ petitions are accordingly allowed.
Highly obliged, Lordship.
This, I'll take this. Huh? I will come, right? In view of the disposal of the main case, the IA is also accordingly disposed of. So that way you can tell them this is the order. They won't know. Yes, huh? 6, it's item 6. It is actually number 6. Infection. Huh? Being beyond the competence of the MAC. Huh? For settlement of the for settlement of the fisheries within the MAC area, being beyond the competence of the MAC, is hereby satisfied. Yes. What is the case?
Yes, Lordship, this matter pertains to the release of the subsidy. Your Lordship kindly comes to section A, page 16.
Yes.
Yes, Your Lordship sees that this is for the 12 plan periods. The Keyboard of India initiative, Your Lordship, it's a scheme.
It is 16, Keyboard of India, yes.
The modalities and scheme guidelines, key development and promotion scheme.
This is for the 12 plan period 31/3/17. What?
No, in fact, what happens, Your Lordship, we kindly come to page 56 for the effective date of this plan. Page 56.
Yes.
This letter is not permitted to read, Your Lordship. Here, sir, in partial modification to this office circular number so and so dated 26th of April 2015, I'm directed to say that the modalities and scheme guideline of 12 plan key development and promotion scheme of Keyboard is effective from 10/12/2014 instead of 1/4/2015.
10/12.
It's 10/12/2014. The scheme is supposed to come into effect, Your Lordship, from 10/12/2014. This fact is not disputed.
Okay, so
Now, Your Lordship, for the scheme at page section A, Your Lordship will kindly come to page 31 from page 31.
yes,
Your Lordship sees the first table at serial number 1. We have the region of Assam.
table number 1.
Table number 1, the rate of subsidy, region width. The table, serial number 1.
Yes.
The subsidy, Your Lordship, which has been increased per hectare for replanting and rejuvenation of land, a plot of land, Your Lordship, is now 1,90,137.
Where do you get the one? Okay, 1,90,000. Yes.
Yes. This is-
Subsidy at the rate of 30%. This is the subsidy.
Yes,
rate.
subsidy.
So you know, so subsidy is 30%. 30% of what?
30% of the hectare, Your Lordship, that will be
30, huh?
uprooted and replanted. For all replanting and uprooting of a plot of land of a hectare of tea gardens. there
So
is
for every replanting,
replanting, uprooting and replanting.
for uprooting and replanting,
Yes,
you will be getting 1,90,000 per hectare.
correct. Per hectare, Your Lordship,
Per hectare.
per hectare.
So it's the replanting of the tea bushes, tea leaves, tea, huh?
First we have to uproot,
Tea plants.
then make the
Is it on the basis of the area, not on the basis of the number of trees that you replant? Or area only?
Yes.
Okay.
Query. Now, Your Lordship, what has happened is, petitioner is the tea garden. Your Lordship would kindly come to page 35. Page 35, Your Lordship.
Yes,
Page 35, Your Lordship, we had applied for a subsidy before the tea board in the year 2012.
page 35, we have,
Page 35.
huh?
We had applied for availing subsidies for uprooting and replanting of a particular area in the tea garden, Your Lordship, before the tea board. This letter was dated 2012. This was before the 12th plan came into effect.
Before it came into effect.
There's no dispute again for that. Your Lordship will kindly come to page 36.
No, this is we are for special purpose refund. Subsidy. So you have asked for subsidy only.
Yes, that is.
There was an earlier subsidy scheme.
There was an earlier
Yes.
subsidy scheme.
Okay, so as per the earlier scheme,
Yes, as for the earlier scheme, the subsidy is 89,650.
just a minute,
Yes,
89,650
650. Yes,
per hectare.
this was subsidy.
This is what scheme, that 11 scheme or what? Huh? Then,
Yes,
so when were you given approval?
yes, I was, approval was given your lordship at page 55, but before that, your lordship at page 36 for a moment.
Page 36, yes.
Your lordship would see in the middle portion of the page, there's a small area which says area for which subsidy is sought.
Okay,
Yes. There your lordship would see serial number, section number. On the left hand side, your lordship.
yes.
25 feet and 16.
Huh?
25 feet, the area in hectare is 16.26.
Yes,
And for section number 16, the area is 18.43.
yes.
Yes. Thereafter, your lordship, the NOC was granted, which is at page 55.
Page 55.
55.
Just a minute.
Yeah.
Date of commencement, date of completion. So 25P was completed on 2013, April.
The uprooting.
Huh?
The uprooting.
Uprooting.
Only the uprooting.
How do we
Again,
know?
this is an application
How,
where-
no, Mr. Counsel, please look.
Yes.
It says here replantation. It does not say uprooting. It says here in brackets, it says replantation.
It says uprooting and replantation. In
So, you,
this is the proposed timeline for doing what, because your lordship, it becomes relevant at page 65, 55.
okay.
Your lordship.
Anyway,
Yes,
but as far as I can see,
yes,
you see, uprooted on, the next column you see, page 36, uprooted on.
Yeah.
Uprooted on shows that date of, it's in the year 2012.
yes.
Replanting is until year 2013, that has come before. So,
Yeah.
for 25P, I don't think you have any claim. You can have.
No, absolutely.
Okay.
The claim is regarding,
16. Sector 16.
Yes,
So, uprooting
yes,
was done in the year 2013.
Yes.
And replantation was done in the year 2015.
yes.
If it, yeah. So, okay. You tell him to rectify it, let him rectify it. Just tell him to rectify, otherwise it will always be there. Aadhar.
25P has no dispute to resolve. 25P is taken care of. 25P was concluded before the 12th plan came.
So that is out of the question. So the only thing is 16,
16. Now, the lordship kindly come,
page 55.
page 55. Page 55 is the NOC which was granted to us.
NOC for uprooting and so, but then the sections are not reflected here.
Sections
Are reflected.
Sir,
NOC for section 16 and 25P dated 12/12.
So there was one application. There were two separate sections of land.
Just a minute.
Yes,
There's no objection to commencing uprooting sensor. And the person subject to not. The object to enable to commence and complete the field work within your time schedule without any financial commitment on the part of the subject to submission of. What is the time schedule? You must have given a time schedule when you made an application. Page 35 is your application.
in fact, your lordship, the time schedule here, your lordship, it can be see page 21. Page
Why,
21.
why should I see 21?
No, because the time sheet is implied by the scheme.
Let us see.
Yes.
21.
21. Replanting, replacement planting.
Yes, where?
Yes, your lordship sees clause C, activity specific eligibility.
Yes, yes.
Number 3, uprooting will have to be completed by 31st March of the financial year for which the application has been submitted. Replanting, replacement planting to be completed within 6 months from the issuance of the LOC.
So,
So the replanting had to be completed. There is no dispute to that, your lordship. Replanting had to be completed
within 6 months.
within 6 months. So by,
So your NOC was issued in 2012.
so it had to be completed by
By,
13 June.
correct.
Yes. Yes. There are
And the 12th plan came into effect from 2014.
14. Now, your lordship, you see the subsidy which was given to us at page 57.
Page 57.
57.
Page 57. Yes.
Yes. Section 16, the subsidy in terms of area of 18.43 was released to us. Your lordship says the final cost, which is 16 lakhs 52,250.
So what is the problem with this?
Problem with this is, this was given at the earlier rate.
Huh? Earlier rate, which rate? 11 rate.
So at a rate where the replanting never took place. Now, the replanting never took place at that.
You see, Mr. Kaushal, how many rates are there?
There's only one.
Which is that rate? As per which scheme?
As per the 11th plan, the rate should be 80,000, 80,000 or something.
How much?
80,000 something.
Let us be clear. Let us be clear. What is your case?
89,650.
Huh?
89,650.
Just a minute.
Yes.
As per 11th plan
Yes.
scheme,
Yes,
it is rupees
89,600.
89,000. 89,660. So you have to get it as per the 11th plan.
That is the question before you.
No, there's nothing. There's no question.
So, in fact, what has happened?
No, let us see a prayer. So you're asking for subsidy as per the 12th plan.
The reason being the state has taken a ground that one application, that entire set of sections which are forwarded to the authorities by way of an application, that application will have to take effect.
Mr. Council, I'm not on that. If you can show me that also, it's okay. You see, the issue is this. All the documents that you have shown me,
Yes.
everything that all the provisions that you have shown me, all point to the fact that you had made an application for uprooting and replanting in the year 2012. Notification was issued in the year 2000, an NOC was given 2012. The provisions require that replanting should be completed within 6 months from the date of issue. Now, that means to avail of the benefits of the 11th scheme, you have to comply with the provision unless that has been put to challenge, that has not been put to challenge. So, you have not completed it as per the scheme. Then where is your case? Huh.
By 6 months period beyond the NOC with which the replanting has to take place. Now, that not being done and the replanting having been taken out in the year 2015, there was an inspection by the team which approved the replanting.
No, but then
There ought to have been a separate application for that. if
that
this
is,
was the issue.
you see, but that does not give you any enforceable right just because then they have violated the scheme themselves. You see,
Yeah.
it's like this. What would happen? Supposing the uprooting was done in 2012, but in 2035, you start replanting and they come and see, they come and inspect your replanting done in 2035 and then they say, it's all right.
There has to be justifiable reason also.
Yeah.
The justifiable reasons have been put forward.
No, show me. Tell me, how can I help you? Show me.
The subsidy is an economic benefit, which is granted. Now, your lordship will see an application to cover all the sections which have been furnished for the authority is a ground which has been subsequently adopted in the 13th plan.
Mr. Counsel,
That
you see,
aspect we
third,
decided to-
you see, 13th plan is not an issue in this petition. So there's not, you please do not make any submissions
Yes.
with regard to
Something which.
something which is not in your pleadings.
Yes.
So let us restrict ourselves to your pleadings. Your cases, you should be given subsidy as per 12 plan, at the new rate as per 12 plan. You have asked for permission for subsidy as per the 11th plan.
Yes.
And they have given you NOC as per the 11th plan. And also directed you that you should complete uprooting and the replanting within 6 months from the NOC. You have not completed it. Then,
But there was no other application.
what right of yours has been violated? I fail to understand.
The right which is violated is by replanting of a particular plot happened within the operation of the 12th plan.
So what? So what? That's what I'm telling you. Supposing you are given the approval as per the 11th plan, NOC given as per 11th plan. Supposing you start the replanting in the forget 12th plan, supposing in the 14th plan, which might come later, then what will happen? Then you will say that no, it has to be as per the 14th plan, a subsidy. How will that work? No, please. I think that's the long and short of it. Yes, anything?
This is our case, sir.
That's the long and short of it. Yes, heard this, sir. Your name is not here. Vakaladama is here? Okay, who's the senior? We'll record huh? Mr. P. Sharma appears on behalf of?
MK Chaudhary senior.
But he's not here before me.
They will slightly understand too much. Mr. P. Bharadwaj's name can be.
Okay.
P. Bharadwaj.
Don't take a risk like this next time. Yeah. Right. Mr. What is your name? P. Sharma, no? M. Sharma appears on behalf of Mr. P. Bharadwaj, learned counsel for the petition. While Mr. S. C. Kal appears for the all the respondents. The petitioner is a private tea company and their basic grievance is that they have not been paid 30% subsidy in terms of the
Tea development and promotion scheme.
tea development and promotion scheme under the 12th plan period. Full stop. He is aggrieved that the petition is aggrieved by the fact that they have been given the subsidy as per the 11th plan period and not as per the 12th plan period. Full stop. Next paragraph. The petitioner's counsel submits that as per
Application 11.
now submits that the 12th plan period of the tea development and promotion scheme, hereinafter referred to as the 12th scheme, Roman 12th scheme, 12th scheme, came into effect from 10/12/2014 instead of 1/4/2015. Full stop. In terms of the unit cost of replanting subsidy of what tea plants or what tea
bushes.
tea bushes for the state of Assam, a subsidy amount of rupees 1 comma, wherever I'm slightly wrong, please correct me. The subsidy amount of rupees 1 comma 137 per hectare was given to the planters after uprooting and replanting of the tree bushes. The petitioner, next para, the petitioners applied for grant of the 30% subsidy as per the 11th plan for uprooting and replanting of tree bushes by letter dated 23/11/2012. In respect of sector number 25 bracket P and sector number 16. Yes, sir. Next para. The Tea Board of India by letter dated 12/12/12 informed the petitioners that there was no objection to the petitioners commencing the uprooting of tea bushes in respect of section number 16 comprising of 18.43 hectares and section number 25P comprising of 16.26 hectares. First up, the letter dated 12/12/12 further stated that the NOC was being issued with an object to enable the petitioner to commence and complete the field work within the time schedule, within the petitioner's time schedule, without any financial commitment on the part of the Tea Board at this stage, subject to submission of 1, 2, 3, 4. That is at page 55 at the bottom. Next para. The petitioner's counsel submits that the uprooting of the tree bushes from sector number 25P, bracket P, and section number 16, pursuant to the letter dated 12/12/12, was completed on 30/12/2012 pursuant in respect of sector number 25P and 15/1/2013 in respect of sector number 16. First up. Further, the replanting of the tree bushes in respect of sector number 25P was completed on 30/04/2013, while replanting of tree bushes for sector number 16 was completed on
10/4/2015.
10/4/2015. Next paragraph. The petitioner's counsel submits that the time schedule for replanting of tree bushes is implied in clause C, bracket 3 of the 12th scheme which states as follows, which states that replacement planting is to be completed within 6 months from the issuance of NOC. What does the 11th plan say? 11th plan is not here. And 12th plan does not support you anyway. Next. The next part, the petitions council submits that as the petitioners had completed the replanting of the tree bushes only after the 12th plan came into effect on 10/12/2014, though it was way beyond the period provided under clause C, bracket 3 of the 12th plan, the petitioner will have to be paid would have to be given subsidy for uprooting and replanting of tree bushes in terms of the 12th plan. That's it. Next. He accordingly submits that that a direction to that effect should be issued to the respondents. Next, Mr. S.C. Kher, learned counsel for the respondents, on the other hand, submits that the submission of the petitioner's counsel read with the documents in the writ petition clearly show that the petitioner was to complete the replanting of the tree bushes within 6 months from the date of issuance of the NOC dated 12/12/12. That is prior to 12/6/2013. As the petitioner did not complete the replanting of the tree bushes prior to 12/6/2013, that is during the validity of the 11th plan, 11th scheme, the petitioner has no right to claim subsidy under the 12th scheme. I have heard the learned counsel for the parties. As can be seen from the documents on record, the petitioners were given no objection certificate to uproot the tree bushes while letter dated 12/12/12 in respect of sector number, no, not sector, section number, section 16 and section 25 feet of the tea garden. Clause C, bracket 3 of the 12th plan states as follows. Page 21. While no, then you write next paragraph. The subsidy application form submitted by the petitioner showing the proposed dates. These are proposed dates, I think. So these are the proposed dates, no, or what?
What I understand from this is that this has been populated after the work has been done.
Okay, and okay, what have I said? No, the report made with respect to the uprooting and replanting of the tree bushes in respect of section 25P and 16 of the petitioner's tea garden. Subsequent to the no objection certificate dated 12/12/12 given by the respondent states as follows. In blue, okay? Just take it down, Page 36. The next paragraph. The 30% subsidy to be given as per the 11 scheme is at the rate of rupees 89,650 per hectare, while the subsidy is rupees 1,90,193 per hectare in terms of the 12th scheme. So stop. Next paragraph.
137.
Huh?
901.
190,137. 190,137, correct? 19. So stop. Next paragraph. The report with regard to section 25P shows that the uprooting and replanting of tea bushes was completed by 30/04/2013 as per the 11th scheme. However, in respect of the section 16 of the petitioner tea garden, the uprooting of tea bushes had been completed on 15/1/2013.
Your Lordship, it's 10/4/2015. Replantation.
No, I'm talking about uprooting.
Apologies.
15/1/2013. And in terms of clause C bracket C of the 12th scheme, the petitioners were to complete the replanting of the tea bushes by 12/6/2013. The 12th scheme came into effect only from 10/12/2014. As the petitioners did not complete the replanting of the tea bushes, in terms of clause C bracket C of the 12th scheme, there is nothing to show that there's nothing to show that the petitioner has any right to claim any subsidy in terms of the 12th scheme. Full stop. Further, the petitioner has not brought any other document and not annexed any other document to show that he has any right to be given subsidy as per the 12th scheme, only because he completed the replanting of the tea bushes after the 12th scheme came into effect. In any event, the reasoning of the petitioner for claiming the subsidy under the 12th scheme appears to be flawed, keeping in view the fact that keeping in view the fact that the petitioner, keeping in, no, it appears to be flawed, full stop. This is due to the fact that assuming the petitioner had completed his replanting when completed his replanting after 20 years, would it be reasonable to expect the petitioner to be given subsidy for a subsequent scheme that may be made only because the petitioner had not followed the timeline fixed as per the earlier schemes? Full stop. Consequently, this court does not find any ground to exercise its discretion in this case. The writ petition is accordingly dismissed. Much okay. How much is your amount claimed?
Amount is around 10 lakhs. Some amount has been given, my lord. Amount has been given, my lord. Now, my lord, in 2019, my lord. Now, presently, I am trying to locate that records, that record, because there is shifting office in GMC, so record could not be located. And my friend also informed that he has also lost contact with the client.
Not only that, Mr. Counsel, you have not mentioned how much you are supposed to get. We do not know. Huh? Look at your prayer.
Prayer is,
Your prayer is to show cause
prayer is-
specifically to the respondent to release the balance amount. What is the balance amount? There's nothing in your writ petition.
only in the synopsis there is.
No, no. So you withdraw with liberty to file afresh. Two 2019 matter, no, even the synopsis doesn't have the amount. Sorry.
Precisely.
He's not making any claim for any specified amount. We cannot ask, you cannot ask the High Court to go on a roving inquiry just for your benefit. You've got to give some idea to the court as to how much is slain by you. You cannot pass orders on speculations.
Amount of 19,68,858 was paid. Out of that amount, 10,67,811 was paid.
Where is it in your pleadings? Where is it in your pleadings? Look at your averments.
Page six.
Page 6.
Paragraph 9, there is, they have start continuing.
Page 6. Paragraph
Paragraph 9,
9.
it starts from
The
page
same time, there are the total bid amount of so and so, and amount that was paid. And how about the remaining balance amount? Okay, so what do you want?
Information.
telephonic info, telephonic contract has you have lost, my lord. That's the way. You have to-
How are you going to contact him? Are you going to go to his house or are you going to write a letter or what? Huh? Going to issue a register? You've got no mobile contact. Last chance, Stephen. Right. Mr. Land counsel for the petitioner pays for time to communicate with his client in as much as he has lost contact with his client. This is the matter after 3 weeks. Why don't you in the meantime find out how much is
Try to
payable?
Look at that file because there was shifting of office in 2 places in the meantime.
Correct, Mr. S. Bora submits that. Due to the shifting of offices, he has not been able to locate the petitioner's file. This is the matter of 3 weeks.
For, right.
Huh?
Very, there was a minor, when a request was made not to claim further instead. And then
No, someone wants to file a reply. Okay, okay.
They have filed a affidavit in opposition. Wherein they have relied upon a minutes of a meeting. That is the.
We list it next week. Okay, list it next week. On the prayer, the parties list the matter on. When?
First week of September.
Huh? When do you want?
5 or 6.
Huh?
Tuesday next week.
Tuesday?
Yeah.
Right.
I think well.
Heard the matter like.
I don't remember. I've got a very short memory. So what is to be done?
My lordship,
Fishery?
Fishery. I have challenged the new order on page on 40, page 40. I was awarded the payment. Thereafter, arbitrarily, the bank guarantee.
Huh?
The bank guarantee was imposed on me.
Bank guarantee was imposed on you?
Yes.
What do you mean
I should
imposed?
give a bank guarantee
For what?
for getting the settlement. Challenging that order, I have filed rate petition. During pendency of the rate petition, they have withdrawn the bank guarantee, but while withdrawing, they have cancelled the settlement. This order I have challenged.
Withdrawing the bank guarantee? What are you withdrawing? You mean they encashed the bank guarantee?
They
They have given back, they have returned the bank guarantee.
no, my lordship. The condition of bank guarantee.
Or the condition of bank guarantee is not required.
To withdraw.
Lordship, here, what had happened, Lordship, I have actually, this new record has given me, it was the old record. But here in this, in his petition, Lordship, he has not annexed the bid document also, which he is relying. We have cancelled it, okay, we have cancelled it on the basis of a bid document, Lordship. I remember, Lordship, that is the thing, while arguing in the case last way.
Bid
Lordship.
documents, so you will be having it. You
No,
mean
he
NIT.
should- He has a petition, he should have given,
Huh?
in his case, Lordship.
Location, my
I am giving, we used to give, Lordship, as per CPC, Lordship, he used to give. As per
Huh?
For
CPC.
one reason or another reason that. My lord.
Adjourning,
Administration of justice, my lord.
he's adjourning the matter.
Yes, my one reason or other.
Okay, day after tomorrow,
The
Lordship.
last
Then
comment,
it's,
my lordship, he, under the last.
Saturday,
Saturday, no, Monday.
Saturday, you have got to go fishing in that ghat.
No, but-
My lordship. For
Okay,
one reason
okay,
or
okay.
Other reason, my lordship.
Okay, there is nothing very.
So what to do?
My lordship, at 2 o'clock may be fixed. in the-
So, without records, nothing is there, Lordship.
2 o'clock, we have already fixed another batch of petitions. 20 and 22. All the senior councils will sit on your head. We have part heard matter we have fixed.
Next week, any date, Lordship. It will be free.
Monday may be, my lord.
No issue, Lordship. I will bring the.
What will you bring?
Huh?
On Monday, what will you bring?
I will bring the tender with documents, but that has to be again translated, Lordship. Because
No, huh?
he has to translate it, Lordship, because on the basis of the tender with documents, we have passed that order, but he has not.
No, it'll go to some other judge. Some judge who understands the vernacular, it'll go.
Lordship, I will translate it in that case. I will translate it and file an affidavit. Give it on Friday. Give me some day, Lordship.
On Friday, my lordship. But because.
Because he has to give, actually, he has to give the,
Where is, he has to give the tender notice, you mean?
on tender bid documents, the conditions, he has not annexed it.
That is not under challenge, my lordship. They have given me the settlement, my lordship. While giving the settlement, they have put a condition that I
let
should
it-
give a bank guarantee. I challenge that condition.
In a different petition.
is different. When pendency of the writ petition, my lordship, they have withdrawn the condition of the bank
So,
guarantee
so that became infructuous.
infrastructure.
Ah.
But while withdrawing the condition of bank guarantee, they have
Let it be
cancelled my settlement, my lordship.
Let it be on fifth lordship.
Cancelled my settlement.
Why did you cancel his?
Lordship, that is further instruction, lordship.
Huh?
Let me complete it. Let me complete it.
And they have
Let me say, if you want to say, sorry, lordship, we have cancelled it because lordship, that he was the second bidder, lordship. The first bidder has quoted very much, lordship, too much, 44 lakhs, and he has quoted around, I think, I don't remember, 22 lakhs. And the earlier settlement was given to him at the rate of the second bidder, at the second rate, lordship. So that is also one reason, lordship. So first,
given my lordship, annexer, my lord, okay, annexer 8, page 14 can be seen, my lordship.
to be called, lordship,
Annexer 14, nothing has been stated.
lordship, here, actually,
Okay.
lordship will, if lordship goes to the record,
Page 14 may be seen, my lordship.
lordship will.
Only problem is, Mr. Counsel, today, he doesn't have anything.
Friday may be fixed, my lordship. I hope
Friday
may
means
go
which,
to the-
when? Friday means what? Next Friday.
Monday may be.
Lordship, next Friday will be the better.
Today is
Next
the
Friday,
Thursday.
I have some another matter,
Monday,
arbitration.
lordship, because I am
Friday
sure
next
on the
lordship.
next day
Ah,
process
Mon-
of actually
Monday.
be there.
He says that you're always running away.
I'm running away. I'm always
Ah.
here, Lordship.
Ah.
In this case, there is. Oh,
My lord,
if he is insisting, Lordship,
Ah.
fix the case. Lordship will dispose. I
I
will.
may lose the case, my lordship. It may not come in my favor, but why?
Let me say, Mr. Counsel, you will say now. Let me say, you are, Lordship, the fact is that I have to translate the text.
Reminds me of that. Reminds me of the Japanese pilot. His name is Chow Mein. So he's a kamikaze pilot. You know, kamikaze suicide. So they ask him, how come you're a kamikaze pilot and you're still alive? He said, but my full name is Chicken Chow Mein. So he's calling you chicken.
Yes, my lord.
Anyway, so Monday.
Monday, Lordship, if he translate the text, then
Say, my lord. Okay.
let it be recorded that he will.
Are you bringing the bid documents? Then,
I will bring my lord.
Okay, then it's okay.
With the- with my lordship. I translate, I will give them on Monday.
on Monday.
All the burden I will take.
Okay,
Okay, very nice.
okay, right. Mr.
Yes, my lordship.
S.B. Raskar, learned counsel for the petitioner, submit that he will produce the bid documents along with its translation on Monday. Mr. P. Sharma submits that the matter can be disposed of on Monday.
I will bring the records of that.
Mr. P. Sharma and Mr.
He
Ah,
wants,
yeah,
he has
Tapada
asked
for
appeal.
Congress.
I think he wants to.
My lord,
Submit that the matter.
for 1 year, on the last occasion, he said he did not have authority. Now he filed a Panama. Then if I want only delayed techniques, my lordship.
Now I got the power and I have already filed my Appagatnama matter.
So actually, his affidavit is necessary, I think.
2 weeks was taken, my lordship. On last occasion, 2 weeks.
Correct. Then he said that Vakalatnama not issued to him. Correct. Right. Mr. A.S. Tapadar submits that he has been given Vakalatnama by respondent number 6 and he has filed the same in the register. List the matter on Monday on which date an attempt shall be made to dispose of the respective.
He may file.
My respectful prayer will be instead of Monday, my lord, can it be on Wednesday, my lord?
Wednesday, you'll be the only one coming here. No one is coming here on Wednesday. You file your affidavit by Saturday. Huh? Saturday open. Saturday is court. After tomorrow is court date.
It is third also lots of
Huh?
third lots of cases are fixed. In third also like one day lots of third is also will not be that many. Monday third, third 1 day will not be different. He can file the affidavit also.
10 minutes, my lordship, for your lordship to decide. My lord.
Mr. A.S. Tapadar shall file his affidavit within 2 days.
Let it be on the third lordship. I think we need to.
Monday.
Okay, lordship. Yes, right.
Arun Patel,
Very well.
So here some lordship, educate amount lordship or contractual bill lordship. This educated lordship, they have the file educated lordship, they educate the amount lordship. Only they say that lordship, when they will get the amount for deputy commissioner, then they will pay bill lordship. This is the lordship, that lordship. So by humble, their lordship. Whenever discussed with the direction lordship, they will.
Admin, how much is there? 15 lakhs, 88,000?
Yes.
Yes, madam. Who is there?
Now, whatever lordship, they will manage lordship.
Yes. Who is there for the respondents?
Lordship, the work was completed under CRF scheme, and in CRF scheme, Deputy Commissioner makes the payment. We are only the executing authority.
Who is appearing for the deputy commissioner?
Lordship, Deputy
Ms.
Commissioner.
Das, you are appearing for the DC?
Party here.
Yeah, this is the party lordship, because we are not a connection to the DC lordship. They lordship, a contract lordship, given the contract lordship and a party lordship. The deputy commissioner, so far our category, deputy commissioner was the petition party of the category.
It's what scheme? CRF.
Yes, sir, Lordship.
CRF,
Now it's
what is the
SGRF scheme.
huh?
Now it's converted to SGRF scheme.
SGRF?
Yes, sir.
So earlier it was CRF when
Yes.
he was doing the job.
Yes.
CRF, what is the full name? Full form.
Lordship, Calamity Relief Fund,
CRF, Calamity Relief Fund, and now it is
SDRF,
SGRF,
SDRF.
SDRF.
Yes, sir. State
Yes.
Disaster Relief Fund,
Okay. So this is payment is to be done by the DC in both.
Deputy Commissioner.
So DC has to be made a party.
Yes, sir.
You are only the monitoring agency.
Yes, sir.
You make application for imprisonment.
I can lordship, can I make it?
Huh?
Deputy commissioner, I can lordship.
Not allowed anymore. Because since everything is being computerized, there has been notifications also issued by this court. It cannot get uploaded. You have to make application.
Why can actually this is their area. They have to collect the money from the deputy commissioner, they have to make to be lordship. Actually, in my case, lordship, I cannot make the LSP deputy commissioner, that he is not paying me lordship, because he given me the contract lordship, and he has to pay me lordship. And he has to take the lordship, whatever he will pay lordship.
Mr. Counsel, now you see, that is what they're going to write in their affidavit. You see, when they write in their affidavit that thing, so what is so difficult by a pleadment? Or what you can do is you can withdraw and file afresh, then it will be disposed of only, but then that will be a problem. Because the affidavit is here. Right, Miss
DG.
D. Jain, then counsel for the Water Resource
Water Resource
Department,
Department.
submits that the work done by the petitioner was under the erstwhile Calamity Relief Fund, bracket CRF, which has now been renamed as
SDRF.
State Disaster
Relief Fund.
Relief Fund, bracket SDRF. She submits that payments for the same is to be made by the district commissioner's office. And the water resource department was only a supervising / monitoring agency.
Executing authority.
Ah.
Executing authority.
Was only the monitoring and executing agency. Mr.
Yes, sir.
S. Hawk, learned counsel for the petitioner, submits that he will file an application for imprisonment of the district commissioner concerned. This is the matter after 2 weeks. You file before that, it will come before that. You file it tomorrow, it will come day after tomorrow. You file it, you just make an application. And then you come and you ask for listing, you list it. It's small issue.
Obliged.
Because they have admitted everything. That's why the chief engineer has admitted.
Yes.
So it's only that, because later on what will happen is, at the time of, at that direction passed, direction will be passed and most probably they will not do it. So you might have to go a step further also.
14 and 15.
Hello. Last time, the lordship was engaged because the pagination of the file was not.
Yes, 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 yes.
And we need more time to. The file has become so.
Okay, no problem, no problem. You need time.
I would like to cause more anguish to your lordship
Yeah,
regarding this pagination. So my lord, the matter may come up next week. Fine.
Okay, right.
My lord, could it be on Wednesday, my lord?
Wednesday.
Huh?
Holiday.
My lord, could it be Tuesday? My lord? There's some urgency on our
We-
part also because everything
We,
is,
there are a lot of, yes, we can fix it, no problem.
we'll take a chance, my lord, on Tuesday.
You take a chance, no problem. All right, on the prayer of the petitioner's counsel. On the prayer of the senior counsel for the petitioner who submits that pagination of the file, of their file has not been done as per the court records, comma. List the matter on Tuesday.
Yes.
List the matter on Tuesday, comma, by which date? Pagination on the petitioner's records should be done.
As many holiday, my lord, as many respite. So I didn't know fourth was a holiday.
Item 16.
My lord, this matter may be passed over for the time being, my lord. Mr. Deenath, senior government advocate, he is appearing in the matter, my lord. An instruction is also there, can be disposed of. Obliged, ma'am.
Item 17.
Very, very good. Let's see, matter related to the non-effect of area, what water bill.
Yes,
Well, I've got the instruction after some time, madam. I've got the code. Yes. madam. Well, the claim amount is 1 crore 15 lakhs 99,655. They've admitted it otherwise. I would like to file one short affidavit when the amount is.
okay, right, Mr. B. Gogoi, learned counsel for the PWD.
Got sir.
Submits that he has received instructions which is to the effect that the respondents have admitted the claim of the petitioner.
Yes, ma'am.
However, he needs a week's time.
Yeah,
Huh?
1 week's time. madam.
He needs a week's time to file an affidavit. List the matter after a week.
Got sir.
Item 18.
List the matter, list
Give
the,
a date, madam. Next Friday,
okay.
I will file it by Monday. Admitted amount, madam, it can be closed.
list the matter on 6th. Or what? Or after that? No, 1 week after that. So list the matter on 9th. 9th.
9.
Item 18.
Yes, who's appearing? APDCL. APDCL. Where are they? What to do?
Okay, coming.
My lord, we have recently received the instruction, well, some time to file it.
Shifting of it.
What is the instructions? Let us see. You are basically saying that he has to pay the shifting cost. Yes, Mr. KB Patel. We are basically saying that he has to bear the shifting cost.
Yes, sir.
Can you just put your transformer in any portion of a private land?
May I have a look at the instruction, Your Lordship, perhaps? Lordship, I may be allowed to, perhaps these instructions are not complete, Your Lordship. Whether the transformer was pre-existing or how it came to be installed in his land in the first place, that is pertinent.
That is there.
That is the,
That is there. That is, if the transformer was there prior to him being the owner of the land,
that,
and how long has it been there also, all those. Okay, right. Mr. K.T. Pathak, Learned Counsel for the AC, they said we granted 3 weeks time to obtain instruction and file affidavit. This is a matter of the 3. Item? Okay.
Yeah. Contracts area, right, because they will- And we have high amended cost that is. But in the meantime, highlight being sent to the bank. It is in a way, but it, of course, the figure is less. Or like, we are happy, happy with this, whatever decisions.
Your name is Mamtaz Ali or Mamtaz Ali?
Single but the account, a part payment has been made, but the bank statement is.
So he's Mamtaz or Mamtaz?
Name is the account Mamta, that's why your lordship asked me to highlight.
In what account? Bank account. Bank account is Mamtaz. And work order is Mamtaz.
Your lordship asked me to highlight it, then highlight.
Yes, madam.
Single.
Lordship, yesterday also similar matters has been disposed of.
So same,
Yes, yeah.
same. Jal Shakti matter.
And
Heard, Mr. A.K. Hussain, Learned Counsel for the petitioner. Miss D. Jane for
For Water Resource Department.
Water Resource Department, while Miss, 1,
Corner number 1, 3, 4 and
1, 3, 4 and 5, while Miss R.M. Barwa
for Finance Department.
for the finance department,
Yes, sir.
finance department. And for, and Jal Shakti,
Sure, sure.
and appears for, CDC appears for the Ministry of Jal Shakti, okay? Then where is the admission? Sit, huh? Speech?
Para 5 million.
Not para 5. I want the admission. Okay, para 5. Okay. How much has the petitioner claimed? Asha, petitioner has claimed 4,45,146. Okay. Then you just write, next you write. Then everything else. So then you write, I've heard the counsel for the parties. Para 4, 5. Para 4 and 5 of the affidavit filed on behalf of the respondent number 3. That is the Chief Engineer, Water Resource Department. Is to the effect that the admitted balance amount payable to the petitioner is rupees 3,96,85. So you pay this amount, huh? So we'll say no more re-verification. Amount has to be paid. We'll make the correction later. As per yesterday's order, say it will be slightly different. There will be no admitted liability statement. It's only because of this. You just say para 4 and 5 of the affidavit in opposition filed by the respondent number 3 by the chief engineer, Water Resource Division, is reproduced here in below as follows. Within how much? How many months?
5 months.
No, because you see in the other cases, there was some there was letters issued by the ministry to the state government asking clarification. So we directed that clarification should be given, and within 5 months it should be everything should be done, paid, even payment. It is an issue between the state government and the central government, nothing between. So they have admitted your amount. 5 months. Same.
Right, sir.
This post.
In 24 orders.
Love just to refresh. Our memory.
Megako. Yes, sir. Yes,
Lord, the bone of contention is at page 82.
82.
Yes. Now, assuming my lord, what the state is saying is correct, I'll satisfy your lordship, still then, we, my lord, meet the requirement. Please come to A1. At least one similar work, minimum value of 150.761 crore during the last 7 years prior to the last stipulated date for completion of the deed. So if I can satisfy this requirement, we need not go to the other. Of course, we'll have to satisfy B, that physical criteria. Am I clear, Miller? We have to satisfy both similar work experience as well as physical experience criteria. Am I clear, Miller?
Yes.
Yes. Now, my lord, kindly come to page number 218.
Two one A. Yes. 2A1 you mean?
218.
Page 82.
No, page 82 I have referred.
Uh-huh.
Now I'll have your lordship's kind attention to page 218.
218.
218. This is the completion certificate in respect of my lord IIT Guwahati Road. This is by Uttar Pradesh Rajya Nirman Nigam Limited. In continuation of completion certificate dated 18/11/23 issued by this office, this is to certify that Mr. Bharti Rai and Company so and so has successfully executed contract work construction of 170 units in G+10 at a type residential tower at IIT Guwahati campus at a cost of rupees 156 crore. My clear with that? And my learned friend the other day while making his argument, he said, with regard to IIT Guwahati, we have no issue.
Yeah.
The affidavit also this. So my lord, by the at page 218, we made 2A1.
Yes,
Now we are supposed to meet B1 and 2. My lord. Am I clear? Please come to B1.
yes,
The bidder should have completed in his own name at least one construction of basement work in the last 7 years. Kindly mark one very significant thing, will aspect. Here the value is not mentioned. All that the requirement is the bidder should have completed in his own name at least one construction of basement work in the last 7 years. For that, please come to page 222. For appreciating my argument, will not logical for a moment will not take note of the value of the work because that is not even the criteria. In continuation of the completion certificate dated 24/11/23 issued by this office, this is certifying that Badri and Company has successfully executed contract work, construction of new Meghalaya Legislative Assembly building at a cost of rupees 170 crore. We are not concerned. Kindly measure component. The building is G plus and basement plus 4-story. Now, my lord will kindly come to page 82 for a moment again. The bidder should have completed in his own name at least one construction of basement work in the last 7 years. So I have done it, my lord. It does not specify the money to monetary part, my lord, or the value. Then 2, B2, the bidder in his own name should have completed at least one construction work with 700 number of piles or more with 500 millimeter dia or more and depth of 16 meters or more in a single project in last 7 years. Now please come to 218 again, my lord. The one I referred for the value. Kindly come to Roman 3. Details of piles work are as follows. Dia 600 mm, requirement is 500. Depth 26 meter, requirement is 16 meter. Number of piles 1800, requirement is 700. So my lord, I meet all the requirements. To this, in their affidavit, they have not disclosed it. Now, my lord, please come to my lord, will kindly come to page number 361. This is the minutes of the bid evaluation committee on 14/6/24. After my lord narrating everything, please come to the last subparagraph. After tradeware discussion, the bid evaluation committee suggested to make correspondence with IIT Guwahati and PWD Meghalaya for verification of documents with reference to IIT clause 2A, 2B as submitted by Badri and Company in order to bring more appropriation of submitted documents. My lord, my first objection is it a case that there were some doubt about regarding only my document, or from the day one, the idea was to out me on some pretext of the other? Can it so happen that in respect of others, there were no issue because you have chosen only one out of the balance 3? I don't stop there, my lord. Under the tender clause conditions, under clause 13, they can revert back to me. If they would have reverted to me, then I could have explained what I've done before, my lordship. That is how prejudice has been caused. Please come to now, my lord, clause number 13 at page number 71. First, my lord will kindly come to page 31, 71, 13.9. The bid will be checked for eligibility as defined in IIT clause 1.7 herein before, and for submission of documents as per IIT clause 20.1. After and will be evaluated for qualification criteria mentioned in IIT clause herein before, and also in conjunction with the provisions of IIT clause subclauses 1.8 or provision given elsewhere in this tender document. And this is important. Request for clarification deficient document from bidder shall be
No, where are you reading?
page number 71.
Yes.
13.9. Last four sentences. This sentence starting with request for clarification deficient document from bidder shall be asked to system. A system generated SMS alert will be sent to the bidder when clarification deficient documents are called to the system. In such a case, no separate communication will be sent in this regard. Non-receipt of email or SMS will not be accepted as a reason for non-submission of deficient document or confirmatory document within the specified time. The date and time of submission of deficient document cannot be extended. Then please come to me, Lord. 13.13. The heading is evaluation of bids. Now please come to C. If required, employer may ask any such tenderer for clarification deficient document on his technical bid through Assam e-procurement portal or through email. The tenderer shall furnish the same online only in case clarifications are sought through Assam e-procurement portal and through email if the clarifications are through email. If the tenderer does not submit the clarification document requested by the specified time, bid of such tender is likely to be. Well, instead of writing to Meghalaya, all right, you have written to Meghalaya, is okay, that also you're not taking an offense. But you could have asked me, then I could have explained this is the position. So therefore, my humble submission is, here is a case, the authority arbitrarily rejected my technical. I fully comply with the requirements and this is in under both the criteria. It's a very simple case, my lord.
Their case is otherwise.
So they say that there is some doubt regarding the amount of work of Meghalaya. So let us not go to trouble ourselves without those. So you have taken note of a consideration which is irrelevant.
They have gone to, I think,
They
nine.
say, my lord, the work order was for the value of rupees 40%. So it could not have been more than 96 crore. And the work value was 17. We are not taking help of those. For the basement work, I'm relying. Because for that, no value is specified. All right. Your concern could be genuine. We are not saying nothing wrong. But then there are other, aspects were there to which you could have reverted, to which you did not. So therefore, my right under Article 14 area. That is my case.
And Mr. B, over your case is under that 6A and 9B5.
The moment, my lord, the petitioner says that, my lord, this particular documents of, my lord, Meghalaya is not to be considered, then, my lord, it doesn't qualify in the basement part. It's not that, my lord, we will consider only the, my lord, experience part and whatever figures are there, my lord, if they doesn't tally with the, my lord, certificate issued by the prime contractor, he is a subcontractor there, as well as the authority will issue the work order to the prime contractor. Definitely doubt will come. And, my lord, we have resorted to a clause, my lord, lordship has just now spelled out. Under that clause, my lord, we have, my lord, cancelled this technical bid. Not on the, my lord, part of amount, my lord, value of the work. That we have explained in the affidavit.
Where is that again? Clause 6A, where is
The
that?
lordship will find at page 85.
Page 85.
85. The second line, my lord, or issued by so and so is subsequently found to be false, fraudulent, or repudiated by the said bank agency third party. In such a case, besides so and so, we are not resorting to my lord blacklisting and all, but at least we have the authority, my lord, to not consider his bid on this particular point, and it is very clear from our minutes. And my lord, so far as the verification part, it was done for all the 4 bidders who were submitted. It's not that only, my lord, in case of the petitioner, we
Can you again show me that 40% issue that?
yes, sir. Doctor may kindly turn to page. Page, my lord, 359.
Huh?
Page 359 of the affidavit that we have filed. I am showing the, my lord, various correspondence that we have made, my lord, from the initial stage. 359. It is dated 4/6/2024.
This is C Assam.
Yes, madam. To the project manager, UP Rajakiya Nirman Nigam Limited, UPRNNL.
Yes.
But here, my lord, we have, my lord, sought for information regarding both the works, because, my lord, the IIT as well as the work in Meghalaya was issued to the petitioner by the same authority.
What was the document that submitted?
My lord, that too, work experience certificate issued by the authorities, madam. Yes, that's not place. One is, my lord, 221 and 218. 221 it is the IIT, 221 is the, my lord, Meghalaya part. Issued by the UP authority.
221 is IIT.
221 is Meghalaya.
Okay.
IIT is, my lord, 218.
218 is IIT.
My lord.
Is it?
Yes, yes, ma'am.
Page 221 is Meghalaya.
My lord, will kindly see, my lord, something is, my lord, not
Just a
telling me
minute.
the paging nation. In my,
Huh?
it is 222 in my bunch. And that certificate is 217. Page 217.
218 is to whom it may concern.
Yes, 217.
Huh?
Yes, if it is, my lord, that, my lord, to whom it may concern, dated, my lord, 2011-23. This is, my lord, IIT.
Is IIT.
Issued by UP Rajakiya Nirman Nigam. Then, lordship will find that page 222, the other certificate.
221 or 222?
221. 222. In my bunch, it is 221.
222.
It is dated 1/3/24.
1320.
Regarding, my lord, New Meghalaya Legislative Assembly Bill.
Yes. With the 4 major components.
Yeah.
mentioned.
Now, my lord, in the next page of our affidavit 360, we received a mail from the UP authority stating that, my lord, so and so certificate, so and so hereby has executed. They have stated that, my lord, the petitioner has executed both the works as contractor under UP Rajakiya Nirman Nigam Limited.
Yes. Then
Then, my lord, in
Page 361 is the minutes. After receiving this report from the, my lord, UP authority. After threadbare discussion of the bid evaluation last para, the committee suggested to make correspondence with IIT Guwahati and PWD Buildings Meghalaya for verification of documents with reference to ITT clause 2A and 2B as submitted by Badri Rai and company, that is a petitioner, in order to bring more appropriation of submitted documents.
Yes, yes.
Page 362, this is a letter of the special chief engineer, PWD Buildings Assam, to the, my lord, chief engineer, PWD Meghalaya. Lords, you will see, my lord, there is a chart given. We sought for information regarding this, my lord, on 7 points. Name of the work as per contract agreement between PWD Buildings Meghalaya and UPP RNNL. Actual completion work value, name of the prime contractor, name of the PMC if any, name of the design consultancy if any, role of UPP NNL in the work as per official record of so and so, role of Badri Rai, that is a petitioner in the work as per official record of PWD Buildings Meghalaya.
Yes.
In page, my lord, 363,
Yes.
my lord, that is a letter to the IIT Guwahati. Now, Lord, you will see that page, my lord, 364, the reply from Meghalaya. It is dated 23rd of July 2024.
Yes.
Page, my lord, 365, Ada, my lord, information, that 7 information that we sought for. Lord, you will see, my lord, serial number 2. The actual completed work value in crores is 242,14,000,000. Within bracket, my lord, rupees so and so, only revised from 127,7598,465. So the actual value was 127 crores. It was enhanced to 242 crores. That's the revised rate. Now, my lord, serial number 3. Prime contractor is UPPR NNL Limited. Serial number 7. The bid petitioner is the subcontractor. Now, how he became the subcontractor, Lord, you will find that. Page, my lord, 366. This is the final work order issued to the UP authority, where the amount mentioned is, my lord, 127 crores. Now, after getting this,
Just a minute. 366 is
the work order issued to UP authority. It is dated 30th of May 2019. Now, my lord, after getting this work order at page 367, the UP authority, they proposed that, my lord, they are going to sublet a particular portion of the work to the writ petitioner. Their proposal is that at page, my lord, 367, dated 10th of July 2019.
limited to 40%.
Yes. They themselves said that, my lord, as per the tender clause, it will be 40%, and the figure will be 51 crores, 51.08 crores. And in the last line, they said the credential of the agency is enclosed it for ready reference. After verifying everything, the Meghalaya authority at page 368, by letter dated 9th of July 2020, approved the proposal, limiting the, my lord, work of the petitioner, who will be the subcontractor, to 40% of the entire value. So it was mentioned as 51. Now, Lord, you will see at page 369.
Yes.
The subcontract order has been issued now to the petitioner. Dated 19/8/2019. After 3 months of the approval. Here lordship will see now the figure started, my lord. Increased, well, it has been increased to 85 crores
Next.
from 51 crores. In page 370, the work completion
Now
certificate,
85, okay. Okay,
then my lord, at page 370, the lordship will see the work completion certificate issued by the UP authority on 24/11/2023 in favor of the petitioner. Here the figure is, my lord, 170 crores. Initially 51, then 85, now it's 170 crores.
this is the document that was submitted by them.
Yes, as well as, my lord, 372. The certificate again, my lord. Here also it has
There
been
about
mentioned.
371, what is this?
It is a work completion certificate and another certificate issued by the same authority on the same works. There also the same figure appears, 170, page 372. It is the same certificate which has been annexed at page 221. 221 of the petition.
So petitioner submitted 370 and 372.
Yes, ma'am. 371 and 372. 370 and yes, 370 and 372. And these documents were put to verification. Both from the UP authorities as well as the Meghalaya. And my lord, 373, my lord, is the reply from the IIT. There is no dispute regarding this. Though we have annexed it, there is no dispute. 373.
What about this?
This is the, my lord, reply of the IIT authorities. They say that, my lord,
So IIT too, there's no problem.
yeah, that's why we have annexed it. There's the reply. And finally, my lord, 374 is the impugned, my lord, my lord.
So as per 373, you are
Yes.
eligible.
My lord.
But your issue is not with the eligibility now.
Yes.
It's with the giving of false information.
Yes, my lord. That is the case. That is our case.
That is their case, is that what you think?
They say we do not meet the value part. That
Okay,
is their case.
in the,
So, my lord, from their affidavit. My lord, my learned friend, the argument he has made, with all respect, I'll submit, this is not even necessary for, on the face of the argument which I have made today, my lord. My learned, this argument is not at all required. I have not even.
no, but we have to give him a
Let
chance.
me complete, my lord. Last, my lord, 374. This is the, my lord, impugned minutes. Lordship will see the last para,
374.
374.
Yes.
After trade fair discussion, my lord, last second para. After trade fair discussion, the bid evaluation committee found that the bidder name Badri Rai and company to ensure has misrepresented their documents. Therefore, committee decided to technically disqualify the bidder as per clause 6A. It is very categorically mentioned. It is at page 85. Lordship has just now gone through it. This is the ground, my lord, of our cancellation, not on the valuation part. Because of the discrepancy in the figures mentioned in the certificate, finally, we have, my lord, resorted to clause 6A for disqualifying the.
After the bidder has misrepresented the document, then
And in the para above that, my lord, the committee gone through the documents thoroughly and found discrepancies in between the submitted credential document for support of work experience criteria as per so and so, along with the bid, with the information received from Meghalaya PWD. This is the ground. We have taken the decision, my lord, as per the terms and condition of the contract. And regarding the clarification part, it says that the authority may, it has nowhere said it will have to. Page 72, 13.3 C. If required, the employer may, after getting all this information, can he say that, my lord, this document is fake? 170 ordered, my lord, 51, my lord, crores that has been issued by Meghalaya. Can he say that, my lord, this is not the figure? These are the documents, my lord. They cannot dispute it. There is no question of, my lord, now having a clarification from the petitioner. My lord, page 72, 13.3C. It says only if required, the employer may ask. We are already satisfied with the document. We need not have to seek any further clarification from the petitioner. Because he cannot change his documents. This has been given to us by the,
What was the document submitted by the petitioner? 370 and 72.
yes, 370 and 72. In fact, I have got the bid also, technical bid.
Okay, okay. One thing is that your case is basically that he was to be given a subcontract not beyond 40% of the estimated amount.
My lord,
Now that estimated amount, that estimate has gone up to 2.4.
Right.
Now his documents show that he has been given contracts beyond the 40% year.
yes. Even if.
170 crore.
170.
Now supposing he actually has been given this amount of work. That
Even then, so far our party.
supposing he has been given this amount of work,
Yes,
though he was supposed to be given only 40%.
96, yes, 96.
Then what happened?
My lord, whatever decision we have taken.
No, then
based on the
wait,
figures, we are
wait,
proud of that.
how can you say that he has given you a false document? Supposing he has really done that amount of work, and though initially he was supposed to be given only 40%, and he has been given that amount, let's say 80% or 70% or what.
No, we are not on that, my lord. How he can, my lord, work beyond 40%? That's the issue to be decided by Meghalaya.
No, huh?
When we found the discrepancy in the figures, when you say that it's 51 crores, the Meghalaya authority has issued. The work order issued by UP authority is 85 crores. Then completion, it says, my lord, 170 crores.
That 80%, that 80 lakhs can be considered in a way, I'm not sure. In terms of the before the cost escalation or before the revised estimate.
Yes, my lord. That's why I'm saying, that's why we have.
So
stated figure.
you see, because so that 85 lakhs can be considered in terms of the pre-revised rate. Maybe,
No,
we don't, I
no,
do not.
Pre-revised rate will be 51 crores. It has been mentioned in the work order. The
No,
approval says that, my lord, out of, my lord.
no, pre-revised rate. What is the pre-revised rate? This is
Yes, it is
1.25 or
mentioned,
something
also you
like
find it
that.
at page.
125 crores or something.
No, it's there.
134. 134.
It says, my lord, it is 127.
127.
Yes.
So what I'm saying is, you see, this 85 might be equivalent to
Well,
170. If we are say assuming, is this loud thinking?
Lordship.
If that 127
Yes,
can be considered to be the revised estimate.
pre-revised, yes.
So that 85 may be equivalent to 170 after revision. Maybe.
After revision, it is, my lord, 242. That is the
Correct.
final
So
amount.
the 85 now comes to 170.
85 will go to 170. In that, my lord, percentage.
Could
No,
be.
No, it could be. We are not on that, my lord.
But now the issue is this. Whether the petitioner has given a false document, that is it.
Lordship.
Now, he has given a document.
My
And
lord.
he might have done work for 170. Though he was supposed to do work for around 100.
My lord. Then 96.
He was supposed to do work only for 100. But he has done work for 170.
My lord.
Now, what is his fault?
But this is the decision of the authority. my
No,
lord.
I'm asking you.
fault.
I'm asking you.
I want-
I have to pass an order.
Yes, my lord. I am-
That is why I'm asking.
Yes.
I just want you to
No,
clear my doubt.
what transpires from the, my lord, minutes, simple minutes, is that, my lord, when they compared all these documents, right from the document that is submitted along with the technical bit, and as well as the clarification and other documents received from the Meghalaya authority, initial work order, then, my lord, the approval for subcontracting, then the order for subcontracting, where it is only, my lord,
Agreed. The UP contractor
my lord,
asked that he be allowed to subcontract part of the work
my lord.
to the tune of 40%. Meghalaya has allowed.
Yes,
However, the UP contractor has given beyond 40%.
Lordship.
Now, beyond 40%, maybe without the knowledge of the Meghalaya
Lordship.
PWD.
Yes.
And the petitioner has said that I have done this much work. And I'm giving you this document showing that I've done this much work. Now, just because the contractor, the principal contractor has given me work beyond the permissible amount as allowed by the Meghalaya, that does not mean that I've given a false document.
My lord, whether, yes, my lord, that of course, I leave it to your lordship, but my lord, whether this honorable court can, my lord, go into that, my lord, aspect.
No.
Decide
So
whether
that
this
is what I'm
document-
thinking.
Because
I'm
lordship
thinking
will
about-
only see the decision-making process.
No,
whether we have-
maybe you should give them a chance of hearing,
Before cancellation.
because because these aspects, let them clarify. Because it could be,
My lord,
you see, because they are saying that they have done this work.
yes,
The principal contractor has said that they have done this work. The problem is that they have lied to the Meghalaya PWD, that's all.
lordship,
But it is not the petitioner who has lied, the principal contractor has lied,
yes,
not the contractor, not the petitioner. So it is between them, from the documents, it appears so. I do not know.
lordship.
There may be more to it than behind the scenes, so. That is,
That can be one aspect to look into the matter, my lord, that giving an opportunity for it.
yes,
giving some
before you take
explanation.
a decision.
But my lord, we have already opened the financial bill. As on that, I have annexed it in the,
Maybe, but we have stayed everything.
yes, it has been said, not to issue any final work order, but it has been
Till
opened.
a decision is taken, don't act upon it.
Yes, then,
That's the only.
then my lord, now since everything is, my lord, very clear, my lord, we have, whatever document we have received from Meghalaya, which otherwise he was not privy to, now he has got it. So, my lord, make him, let him, my lord, make a representation before the authority, and they will consider within a time frame. No. Regarding the technical part, only regarding the technical part.
Fresh financial. Whatever bid is there is there.
So that's why I'm saying, my lord, he will make a representation before the authority, clarifying everything, because he has got all the documents now. In the affidavit, we have annexed everything. Then the authority will take a call, my lord. That can be, yes, within a time frame, say, my lord, within 7 days or 5 days, he will do, 3 days. Another 3 days, we will take a call. Then if they are satisfied, they will open the technical bid and consequentially, my lord, the financial bid will come.
Financial bid, he said that he is 14 crores less.
That, my lord, cannot be a subject matter now. If somebody is not technically qualified, no, of course, my lord.
I've already recorded somewhere. I think.
Yes, that's his submission. That's his submission. But we don't know because we have not opened it.
Para 16 Miller at page 23. We made that statement.
No, I'm not denying that. madam. The statement was.
Anyway,
has
that
been
is
made.
different
There's a
thing.
different
That-
issue.
that
We
is
have
a
the
separate
technical
issue.
part.
That
My
will come
right
later.
is there.
Yes.
No,
It is there.
any other submission you wanted to make?
Yes. If my reference
I
concluded.
think yes, Bob.
Yes. Now, my lord, let us confine to the first scheme of the argument, which we made the other day. I made a different argument today regarding compliance, relying on IIT board. Now, my lord, as far as their part is concerned, if your lordship goes by the eventual minute, they have invoked clause 6.
Clause 6.
Yes, that is misrepresentation. It has already fallen from your lordship, my lord. How can it be a case of misrepresentation? It can be a case of misrepresentation because we have not stated anything. It is my principal client contractor who has said all this. And in fact, my lord, since, my lord, the issue is what is the extent of the value of the work I have done, they have some doubt because Meghalaya has given them certain figures. But as the lordship has very rightly said, rightly or wrongly, I have done the work of more than 150.
That then I have to clarify.
What I'm saying is, we have already done it.
Appears so.
What is their concern? Their only concern, if your lordship will kindly come to the affidavit at page number 353 below. Let us go chronologically down. Let's take 5 minutes. Page 35. First come to page 353. 353. Last two sentence, the sentence starting with while towards the bottom now.
Yes.
While in the completion certificate submitted by Badri and Company, it was mentioned that total value of the work awarded was 85 and odd crore, and total value of the work completed was 170 or odd crore. And same does not tally with the amount mentioned in the above mentioned document received from PWD in connection with the subcontracting of the work to the petitioner unit. And further, if 40% of the completed revised work value of rupees 12 so as mentioned in the later dated of chief engineer is considered, then also it works out to 96.85 crore and not 170 and not crore as mentioned in the work completion certificate. Thus, there is an apparent discrepancy in the work value. So their grievance is, my lord, there is a discrepancy in the work value. They are not disputing that I have done the work. Because it will have a bearing while lordship appreciates my argument which I made today. 2B1. Because for basement work, no value is there. All that I have to do is basement work because of experience. So their concern is only doubt is regarding value.
No, one thing,
Yes,
so you have submitted this, completion certificate amounting to rupees 85 lakhs also.
85 crore was
Crores also.
original value below. But eventually when we completed the work, the value had gone up to
No, that is all right. But did you submit this 85 crore document?
Yes,
So you submitted two documents.
I have submitted IIT Guwahati as well as Meghalaya.
No, I'm not on
Yes,
IIT.
I submitted this document.
Only with Meghalaya.
Yes.
Did you submit this
Because
85
I
crores?
understand, I submitted this document, because my understanding, since the work have went up to the value of 170 crore, therefore I meet the requirement of 150.
Can I see this 85 crore certificate?
Yes. Page number below 218. And the work order is that below. Two one nine is the work order.
No. 218.
219 is the work order.
219.
Yes,
No. Acha, 219.
Yes.
Okay.
219 is the work order. It is for 85 crore.
So this document you submitted along with the
It's
tender.
also along with 218. I have not concealed anything, my lord. It's not that I have not shown my 85 crore thing.
And where is that 170
Yeah,
crore?
page 218.
218 is not.
Sorry, 222. Before that, 220 also below. 220. This is to certify that Badri and Company having its registered office at so has executed the following work under UP Rising Nirman Nigam Limited. Name of the work is so, work order is dated so. And the similar total value of the work awarded is 85 crore. So, value of the work completed is 170. Well, I have not hidden anything.
Page
220.
I get place the technical bit, well, original technical bit, it is there. Not
And my lord,
Page 48
It is
onward,
there.
you can
So
see.
he has given it.
everything.
It is there, yes, page 48, it is.
Only thing is now because of the permission sought for by the UP contractor
yeah.
and the permission given by the Meghalaya government, that threshold has been crossed.
Yes, so he will clarify that by Lordship will already,
So-
that will be a best option.
My lord, that's the certificate given by the authority. 222, my lord. In continuation of the completion certificate issued by this office, this is certifying that Badri and Company has successfully executed the contract work so and so at a cost of 170 crore. And now, my lord, most important is measured component, G+5 and B+2. Even
But-
if they ignore this for the purpose of value, my lord.
But that is not the issue.
There is not.
No, that's what I'm saying. If they could have asked for my clarification, then I could have clarified. If not by this, I comply with by the other means.
No, is that an issue?
Yes, my lord. No, what I'm saying is,
No, I don't want to go, to go here and there.
no, my lord.
The bidder,
What I'm trying to say, my lord,
Huh.
if they would have sought clarification from me, then I would have tried to satisfy them by saying, look here, I have done work of 170 crore, though the work order was of 85 crore.
they're not on that. They are not on two. They are not on clause two, as far as I can see.
Yes.
They are only on with regard to clause 6.
I'm saying it, subject to what your lordship may say, they have confined themselves to only that.
Only to make a liar.
Ah.
That the discrepancy in the numbers, that's all.
They should have explored other options. also.
No, that is,
Because 14 crore is there.
there is
No,
that
In
discretion.
terms of the contract, but I'm not saying otherwise.
Because you see, financial bid will be open later on. That we have to first cross
Yes.
the technical bid stage. So
therefore,
technical,
In any case,
Hmm.
to invoke clause 6C was a wrong decision because there was no amount of misrepresentation at any level from ours. We had said the work order is for 85 crore and value of the work completed in 170. So where is the question of misrepresentation? So why do you need to go to Meghalaya?
no, the mega lie is only for that whether you are
Say-
giving a false information on,
Yes,
right?
yes.
Mhm.
And my lord, one more thing, if your lordship should kindly come to clause number, page number 72, my lord. 6. Maybe.
Page 72, yes.
No, I'm sorry.
See,
No, my lord. I'm sorry.
no, this is not an issue. So basically, it's very simple. The issue is basically with regard to actually 6A and 955.
My lord,
But you have not gone into that. Anyway, it's anyway the same thing.
another thing, my lord.
Alright.
Kindly come to page 83 for it. Roman 8.
Yes,
8.
83.
Page 83, notes, my lord, Roman 8.
Yes.
For experience under 2A, above credential certificate issued by the government organization, semi-government organization of central or state government, or by public sector undertaking, autonomous bodies, or their subsidiaries, etc., 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 shall only be accepted for assessing the eligibility. So, my lord, I have relied upon a certificate given by government of Uttar Pradesh undertaking. So, under the scheme of the tender, it is acceptable. So, they have said both 85 as well as 170. So, where is the question of we misrepresenting anyone? And we got page 360, the UP writes that yes.
Anyway, so the issue is only with regard to whether you have given a false information or not.
Yes.
That's all.
Yes.
So let them take the call.
Lordship.
Yes.
And till the decision is taken, my lord, so far as the disqualification part, that may be kept in address, but my lord, to quash the entire, my lord, technical evaluation committee's decision, disqualifying the petitioner. Till the decision is taken, first decision is taken, that may be kept in address, but because you will also interfere it, then again,
No, that will leave it to lots.
yes.
How to
Yes,
move the
already
order
we have
back.
taken a decision that my lord is not qualified, but lordship will, since lordship is demanding.
No, I will not do anything. I'll just say that there will be your decision.
Yes.
I'll give my reason. And in the meantime, there should be a stay on the,
There should be a
there
reason
should
for
be a stay on the, there should be a status quo as on date.
it. Yes.
Yes. Kind permission have been taken.
Okay, at your parents.
So my friend,
Okay. Okay, just take up from para one. Okay. So, then you just say. The basic issue to be decided is as to whether the petitioner had submitted false information to the state respondents in his bid documents. The minutes of the bid evaluation committee held on huh?
14.6.
The first one,
First one, 14.6.
361, I think.
Yes, please.
Held on 14/6/2024. Resolved that correspondences were to be made with the IIT Guwahati and PWD bracket B, Meghalaya, for verification of the documents of the petitioners with reference to ITT clause 2 bracket A, small a, and 2 bracket small b, in order to bring more appropriation to the submitted documents. Who's that? The next paragraph. The correspondences made by the state respondents with the IIT Guwahati found that the documents submitted by the petitioner with respect to the construction work done for the IIT Guwahati was without any fault. And in fact, the documents on record go to show that clause 2 bracket A bracket 1 and and no, that's the page 1A. Two bracket A bracket 1 of the work experience in terms of the NIT. No, no, it showed that the petitioner was qualified to have done a similar, to have a similar work experience in terms of clause 2 bracket A bracket 1, okay? Of the NIT. However, the correctness / genuineness of the petitioner's documents with regard to the construction of the new Meghalaya Legislative Assembly building under the government of Meghalaya PWD. Arose in view of the fact that the UP contractor in view of the fact that the UP contractor who was the principal contractor who had been allotted the contract work of constructing the new Meghalaya Legislative Assembly building, and asked for approval of the Meghalaya PWD to subcontract the work to the petitioner up to 40% of the estimated amount. The Meghalaya PWD approved the request of the principal contractor, the UP contractor, for subcontracting the contract work of construction of the new Meghalaya Legislative Assembly building to the tune of 40% of the estimated amount, which was 127,75, 98, 465. To cut a long story short, the petitioner submitted the letter dated 19/8/2019 issued by the UP contractor to the petitioner. Not letter, work order dated 19/8/2019 by the UP contractor to the petitioner, accepting the petitioner's bid for subcontracting the construction of the new Meghalaya Legislative Assembly building for an amount of rupees 85,03, 23, 212, along with his bid document. The petitioner also submitted the certificate dated 1/3/2024 issued by the UP contractor, which stated that the petitioner had successfully executed the contract work of construction of the new Meghalaya Legislative Assembly building at a cost of rupees 170,67,05,058. Full stop. It may be mentioned here that the initial estimated cost for the contract work was rupees 127,75,98,465. And the revised estimate value was rupees 242,14,00,000. It is clear from the work value done by the petitioner amounting to rupees 170,67,05,058 for construction of the new Meghalaya Legislative Assembly building, that the subcontract work given to the petitioner by the UP contractor was beyond the 40% limit that had been set out by the UP contractor with the approval of the Meghalaya PW. The issue of the issue whether the petitioner could have been given subcontract work beyond 40% as agreed to by the UP contractor and the Meghalaya PWD is not a question that is to be decided. In as much as clause 6 bracket A of the qualifying criteria for works contracts as provided in the instruction to tenderers bracket ITT pertains to false / fraudulent documents being submitted by the tenderers. The petitioner herein has submitted documents which clearly shows that he has done work beyond which is to the effect that he has done work beyond 40% of the contract amount. The genuineness of the said claim made by the petitioner should be the issue that is to be decided by the respondents. If the petitioner is found to have done work as submitted in his documents, in his tender documents, while constructing the new Meghalaya Legislative Assembly building, the petitioner cannot be said to have violated clause 6 bracket A of the qualifying criteria for work contracts of the ITT. But just because the petitioner has been given subcontract work beyond the permissible limit. The issue that has to be decided and examined is as to whether the petitioner had done the contract work as claimed by him in terms of clause 6A of the above clause 6, and not whether he has done subcontract work beyond what had been agreed to by the UP contractor and the Meghalaya PWD. Next part. The disqualification of the petitioner's technical bid by the meeting minutes of the bid evaluation committee held on 1/8/2024 shows that the petitioner's technical bid has been disqualified in terms of clause 6 bracket A of the ITT, as the petitioner has made a misrepresentation in his document. As there were discrepancies in the documents, in the work experience criteria submitted by the petitioner, in respect of the contract work, construction work of the new Meghalaya Legislative Assembly building, as per information received from the Meghalaya PWD. Next para. As stated earlier, the work experience criteria as provided. No, as stated earlier, the petitioner's work experience in making the construction for the IIT Guwahati at page, which is the page?
Well,
Huh?
I,
218, no. 218,
218.
218. 218. Not, 218. As can be seen from the certificate dated 2011-23 issued by the UP contractor and the physical experience criteria as provided in the certificate dated 1/3/2024 issued by the UP contractor shows that the petitioner has got the has fulfilled the conditions required. Appears to have fulfilled the condition required. Under clause 2 bracket A bracket 1 small, comma 2 bracket B bracket 1 small. No, I Roman 1, I. And 2 bracket B bracket 2 small. Of the work experience. Clause provided in the qualifying criteria for work contracts under annexure 1 of the NIT. Under annexure 1 of the NIT and ITT. Full stop. The next para, as stated earlier, the only issue pertains to whether the petitioner had submitted a false document. Full stop. The petitioner documents having shown that the petitioner had done the work value of 1,70, how much? 1,70, 60, 170, 67, 05, 058. Out of the total revised estimate for the contract work amounting to rupees 242, 14, 00, 000. The respondents would have to take a decision as to whether the petitioner had completed, had done the work value as per the information provided by the petitioner. It is only when the state respondents come to a finding that the petitioner had not done the work value of 170, 67, 05, 058 while constructing the new Meghalaya Legislative Assembly building, that the state respondents can that the state respondents can disqualify that it can be said that the petitioner has given a fraudulent, a false / fraudulent information in his bid document in terms of clause 6A of the ITT. I think that covers it.
Yes, sir. Only thing, well, in between, Lordship has stated that 6A is a qualification criteria. It's a disqualification criteria.
I know,
One
it's
of the
a-
grounds of study.
Anyway, that I'll correct you.
Page number 360.
Huh?
Page number 360.
360.
The issue which is now left open for them also stand satisfied by saying of the principal contractor that it is genuine and correct. Reference to your emails issued by this officer and office in favor of so and so genuine and correct.
Anyway, we'll have.
I just want to-
That you, huh?
Yes, let them submit a representation satisfying the authority regarding their condition.
Right. The issue of whether the petitioner should have been given, should have done only 40% of the contract estimate is not an issue that can have a that can have a is not an issue that is to be decided while considering the petitioner's technical bit. under clause 6A of the ITT. Full stop. In that view of the matter, this court is of the view that the disqualification of the petitioner's technical bit is not sustainable, as the reason for disqualification does not come within the ambit of clause 6A of the ITT. Full stop. Accordingly, however, in view of the fact that the present case is a contract is pertaining to conditions of terms and conditions of a tender. And as the state respondents have not decided the issue in the correct perspective, this court is of the view that the disqualification of the petitioner's technical bid to be reconsidered by the technical bid evaluation committee. Full stop. Accordingly, in view of the reasons stated above, the petitioner shall submit a representation to whom?
To the tendering, who has issued the tendering authority? The tender.
To the respondent number? Better to the respondent, better, that becomes easier. To the respondent number 3.
Yes, please.
Respondent number 3. Showing proof that, giving proof that he has, that the petitioner has done subcontract work in constructing the new Meghalaya Legislative Assembly building to the tune of 170, so. So stop thereafter. The so the representation should be submitted to the respondent number 3 within a period of a period of 5 days from today. 5 days from today. That means 5 days will be what? Today is what? Today's Thursday. Thursday, Friday, Monday, Thursday, Friday, Saturday, Sunday, Monday. Okay, by Monday.
Right.
It's correct. Why 7 days? Huh?
Possible.
Oh, what?
It's from Assam only.
Huh?
So where's the petition?
No, it cannot be 7 days, because 7 days there will be a holiday on 4. So we'll say by on or before.
Yes, sir.
On or before 3rd September. 3rd September 2024.
Yes.
Full stop. The respondents, the state respondents shall thereafter, that the technical bid evaluation committee shall thereafter reconsider the case of the petitioner and communicate the decision taken to the petitioner. Communicate its decision to the petitioner till a decision is taken by the technical bid evaluation committee. Status quo as on date shall be maintained in respect of the NIT in question.
Put 1
That was your ability, sir.
Huh?
The decision
Okay,
of that is Lordship already indefinitely.
Right. Consequently, the minutes of the bid evaluation committee held in its meeting dated 1/8/2024, disqualifying the petitioner's technical bid is satisfied. The writ petition is accordingly disposed of.
So very.
And what's that big case coming up after this? Put it Hello? We have,
The documents are there.
okay. That under that meter. Yes,
We find the affidavit. We send the petition by mail.
Ah.
But not submit because they got blocked. But after getting the mail, officer of law, but after getting the petition in mail, he has opened the law
okay,
today.
okay.
So what I was paying for was that you lost my issue notice. In the meantime,
Is that the interim order which your lordship has passed in the last occasion? That can continue.
subject to payment of the bills by the petition.
Now perhaps we can go and actually take a reading of.
Who will clean up?
We'll clean the bill, we'll get it. We have already started.
Okay, okay. So he has unlocked it.
After getting, put the photograph also.
Okay, okay. Third, Dr. A. Saraf, Learned Senior Counsel for the petitioner who submits that the respondent number 2 has unlocked the gate housing the electricity meter and the transformer. He also submits that cleaning of the undergrowth has been started by the petitioner. This one. Issue notice returnable in 3 weeks.
2 weeks, no?
2 weeks. Petitioner takes steps for service of notice upon the respondent number 2 by registered proceeding within 2 days. Mr. K.P. Patak appears for the APDCL.
So the petition with that below the stamp, getting the visiting.
Yes.
Full stop. No, full stop. The APDCL is accordingly directed to take steps to take a meter reading payable by the and make the bill payable by the petitioner. Petitioner. List the matter after 2 weeks. Interim order. Ask the rate to continue. Till the next date.
Now, once we take a meter reading, that will no
Until and
longer be a
unless,
provisional. That will no longer be a provisional.
We get back also, not so the,
Yeah.
because the problem bill is normally high.
Yes. To continue. Is to continue unless the bill is being generated by the APDSL after taking a meter reading.
Very good.
Okay. Sometimes we have banks in the mail also, it works.
Good. I think it'll become in structures now.
But it's not because again tomorrow, after purchase, you need a picture of it.
Okay.
Item 21 and 22.
What is this?
Along with item 29.
My lord, I have a prayer, my lord, before starting both these sides, my learned seniors, my lord. There is a miscase, my lord, it is 29, that may be taken first, my lord, because I filed a petition, 104 number of petitions, my lord. They want to dissociate from this association, that is my respondent number 3. So they want to agree. But
This IAS with regard to which case?
in this case, my lord, 22, my lord.
22.
Yes, ma'am. They are one name to be struck out from all the proceedings, so that they are agreed to accept the one MO was signed during the pendency of this petition between the management and the workmen. So we are agreed to accept the memo, whatever condition is there, but also accordingly don't want to pursue the letter.
Their choice.
So this is our name.
Last agreement and that they want to.
Accept the MO.
If they are taking it.
And
Okay.
all the other people.
Good because they really.
Mr. P. Mahanta appearing on behalf of the applicants. Applicants
104 numbers, right?
who are the respondents number 42107 in WPC 8150.
No,
Oh, they want to impede.
yes, sir.
They want the. Order so that they will.
But we are the member of the there's association.
who are respondent number 3 in this case.
Ah.
So we don't want to pursue the matter with this writ petition. So
Oh,
what
you want to,
our
you have
name
to
might
withdraw.
not be struck out from the entire proceeding, but we can get the benefit. Otherwise,
No, where is the requirement of that? You go to the, you go to,
Why not the authority, why not my senior, why not, they are aware that unless and until matter name is showing that we are not associated with this case, why not benefit will not be valid. This is the question. But this is the problem, and that is why why not we want.
no, why don't you write a letter to the respondent number 3?
No,
And
madam,
say
no,
that
no, respondent
you
number
want to
3.
leave the
No, no.
union.
Respondent number 3, why not, we cannot, we are not able to.
If you are a member of that union,
We are,
you leave that union. Who are we to?
we don't want to continue with the case as a member of the union. So we want to accept the memo, whatever condition is there.
No.
That is why we are.
So, no, listen. Please listen. There's no point just, rattling and without hearing the question.
Yes, sir.
Now, you want to continue in the union. You want to continue as a member. You don't want to continue as a member. Why don't you go and tell them that you want to leave the union?
No, my lord, if it is, my lord, we go to the union, my lord, that will be not enough, my lord, because unless and until, my lord, we show the document before the management that we are not associated by this, in this proceeding, by showing our name that we have withdrawn, the benefit will not be given, because they will, my lord, object these things on this. But I pray, my lord, that
Where is your letter to the union saying that you want to withdraw from the union?
that was not there, but we have.
No, you. That is the first condition precedent. That is the first requirement.
My lord,
You want to leave the union. You first ask the union you want to leave. If they say no, then you come to us.
no, my lord, one thing, my lord. Here, my lord, number of petitioners, my lord, they have already retired from service. So, my lord, after retirement, there is no question of they are continuing the union. The others are going to be retired. So, my lord, they are, my lord, thinking.
You see, Mr. Counsel, you make a mention of those persons who have retired and those persons who are still there in the union. And you make an application, at least for those persons who are still there in the union. You ask them to leave the union. Who are we to go into the issue of whether you should leave or not leave? You go to the authority. We are not the authority.
That will not suffice the purpose, my lord, because
It might not suffice, but you first go there, then you come here.
the lordship may give me observation, my lord, I can go over. Otherwise, it will be difficult to approach. Problem is this, my lord. Lordship, aware about
right.
it, my lord, procedure of the
Okay,
union.
right. Heard Mr. P. Mahanta, learned counsel for the applicants who submits that the applicants hearing. Now, who is going to write all their names, typing?
It's something they- When the computer, everything is printed in the computer.
So can you give the soft copy or from your computer pen drive? Because these so many names, they're going to spend a lot of time.
I can, my lord, by way of this, my lord, one of this, one of the PDF copy or any other copy, I can provide my lord. What's.
Word document, whatever.
I-
Mr. P. Mahanta, learned counsel for the 104
Oh, my lord.
104 applicants submits that what you want to be included? You said you're already part of the union, no? Aren't you a part of this respondent number 3?
We are being the member of this respondent.
Union is completed.
Members are as a.
Not completed. As I see, possibly they are members of the respondent 3 union. They want to now say that the requirement of that settlement is because that you have to give an undertaking that you are accepting auditor, then you will be given the benefit.
So let them write a letter directly to you. Why should it come to us? I don't know.
No, my lord, the management problem is, when the management is saying, my lord, unless and until, my lord, we can show a document that we are not part of this proceeding, my lord, then, my lord, not, this is a problem. Because as a union, my lord, member of the union, my lord, still we are there, so you want to dissociate from the union, my lord. That is, unless and until.
They should approach us.
Correct. You're the respondent number 3. Yes. They should approach you.
Yes. If they want.
Why should you? We do not know. We do not know whether you are part of the member of the union also.
Well, that will be well checked by the management also, because this is a, this is
Mr.
the.
Council, first of all, if you want to leave the union, tell them that you want to leave the union, get a letter from
Then,
them.
my lord, Lordship may observe, my lord, give an observation that I will approve it, otherwise, my lord, that will not consider. This is the problem, my lord. Lordship,
Okay,
ever, my
right.
lord, the, how to
And
work
Mr.
with
P.
the-
Matala, Council for the applicant, 104 applicants who submit, that the applicants would like to leave the Oil India Thika Shramik Changa and be pleaded in the present writ petition.
Right.
So as to, why do you want to be implemented? I don't know.
my lord,
Why do you want to be implemented? When you're expecting, when you're accepting the thing, I don't know, you're confusing the issue. You're going this the wrong way.
my lord, if I, in so moto, they will, if the, my lord, thinks that no problem, my lord, the so moto, they are not giving, this is the problem. So moto management is not giving the benefit.
Where is your representation to them?
My lord, if it is not there, my lord.
Where is your representation to them?
Till that, my lord, there is not giving. But the
No.
Lordship may, my lord, give a liberty to us.
Mr. Council, you cannot expect the court to do your bidding, your homework, we are not your post office. Okay.
My lord, we are helping, my lord, management, my lord,
Huh?
we are helping the management, my lord, because the management is fighting for against all the union. my
Mr.
lord.
Council, please go to them. If they're helping you, please go to them. Why are you coming to us?
Then, my lord, Lordship give a liberty or the observation that I will approach, my lord, to the management that they, in that way, my lord. Whatever. Lordship.
Wants
But
to
unless
leave
and
the
until, my lord-
so union, huh? First up. On considering no, Mr. P.K. Goswami appears for the
Management, my lord, petitioner, my lord.
for the writ petitioner company. While Mr. B.C. Das appears for the Oil India Thika Shamik Sangha. Full on considering the prayer of the petitioner and the fact that the petitioner has made a prayer for impleadment in the writ petition, this court is of the view that the applicants should first approach the petitioner company. They should first approach the Oil India Thika Shramnik Sangha with a prayer to leave the union. Once the same has been given, the petitioners may approach the petitioner union, the petitioner company with regard to their intent to agree to the memorandum of settlement.
Yes.
Dated
Dated, my lord.
Require them to complete the undertaking.
It is 7/1/2023, my lord.
7/1/23.
Plus even 11, my lord.
Huh?
7/11, my lord.
7/11/23. By submitting a undertaking that they would accept the memorandum.
9/11.
9/11/23. As such, this court is not inclined to entertain the present application as the ground for impleadment has nothing to do with the intention of the applicants to accept the memorandum of settlement dated so. Further, there is nothing in the records to show that that the applicants are members of the Shamnik Sensor, in as much as the membership to that union, in as much as the records to the membership of the union is with the union. We do not know all those issues. You go to them first.
All right, my lord, I will approach, my lord.
The application is accordingly dismissed. Pass. Okay, then come to tomorrow. Tell him to read, tell that to rectify the defects. Now, where are we? I don't know. Can you give me that envelope? I can't read the envelope. You've taken out everything from there.
It is the file.
The file.
UPC 8150.
Just a minute, there's some documents. I know they were put it in some other file. There's another matter. So. Where is Mr. Mahanta gone? He's finished. That was his job only. But I didn't understand why he wanted to be treated. Correct, that's all. Because we do not know if they are members of the union also in the first place. So we might be passing a wrong order. No, there is some other documents anyway. Later we'll look. We'll look for them. Huh? A little bit, yes. Yes. Anyway. Today is 28, not 29. Yes.
Very quickly, and that necessary bank in order to develop the
Got it, but I don't remember at all. Anyway.
completely, absolutely
Yes.
quickly and possible. The company has two sets of employees. One, they have their own sub-recruitment qualification, not a people competition selected. That is called irregular number. But additionally, the company has to have, in view of the nature of its activity, of its production, taking into account, they were a contract. Therefore, they have registered themselves under the Labor Regulation and Regulation Act 1970. So they were registered by the. So we are registered and we get these laborers through the contractor, apply for license, and the license is given under the safety. With the names and the number of the people who are there, all these details are provided in fact and the license of the project. So this is how we got the system was working. I don't want to go back the initial phase, there were a lot of problems. But we started with the 2010 agreements, which are not one agreement is one set of contract laborers, they are called listed one. Page 31. The other is because
Page 31 is the two contract agreements.
Yeah.
Memorandum of settlement. Dated
2010. 2010. 2010. That is for listed one. And the MOS, that is at page 31, and at page 36 below the second MOS is dated 28/5/13.
28, 513.
For, listed two entry,
For
for listed two entry. Roman two, Roman, workshop labor, WCL two entry.
and 11, 8, 2020 for list one.
That is
Listed
for
one.
WCL listed one. It's a 10-year period agreement.
And listed 2 and 3 are also WCL.
So it contains below 2010 agreement. Either page 31 for listed one. It contains below for the first time they are given the basic pay, the minimum of the regular. That was given in 2010 onward in this company.
The minimum basic pay.
Page 32. Starting the pay of grade one of the company's regular employees, presently 4,800. If you take to listed potential, and then when you divide for the regular employees, the grade, divide starting with the pay of grade one, which is the grade employee. Company has got several grades. The starting grade is grade one, and it goes up to grade nine. They are giving promotion, those who are recruited to give us input. And the allowances are prescribed there. So it's 15 for the policy. Page 34 was the report, all the demands have been settled. There, legal team, one thing that one will. Because second one is your option that page 36. That time is certainly. And in page 36, and the page 530. That period is 1,730. So in time by 3.
So what is the difference between the WCL listed 1 and 2 and 3?
Basically, there is nothing in the levels, which occurred during the discussions at different times in the conciliation.
Different salaries or what? Do they get different salaries? The wages are same for 1, 2 and 3. It'll be different, I think.
But because this was signed in 13, as your lordship sees.
No, but why do you make a classification of WCL listed 1, WCL 2?
The length of service prior to 2001 category, WCL 1, they are referring, and post 2002, it's 20,000. It doesn't really have any bearing, they're paid.
Therefore, classification when they enter service. That's all.
People For example, it was 4,800 at that time. By the time the second one is signed with us, the lawsuit fine after 3 years, the pay has gone up to 9,800. Earlier it was 4,000. So it is given equally. There is no dispute on either say among the contractors. The dispute is slightly different. So same things are given and same terms are there. And so this is how we got the forecast perfect levels of this category to our pay. In this case, there are 3 categories of forecast. So it's the security, ethical, and legal and helper. 3 categories, right?
Where, in which memorandum? 2010.
Both.
Okay. There are 3 categories. In both the MOS, there are 3. No,
The settlement,
he's saying no. Look at it. Yeah, your junior is saying no. I don't know. Which one? The contract labor. MOS.
the security stuff,
Subject matter of the MOS.
security, third group is legal and
Medical and third group is?
leader and helper.
Hmm.
Leader strong help. And the order relates to the
The impugn order dated
11/9,
11/9/70. Page 60.
Yeah.
60.
So as this is going on, the present process started when the demand for the first time was raised for saving
For payment of pay scale.
of similar payment, that is at page 1615 and page 42.
Page
Page
42.
42. But started like ITX, they were asking, but subsequently were converted into an application under Rule 25 of the 1971 rules under the contract labor. But I am only indicating that during the currency of the agreement of these 2 settlements, this was raised the dispute. Initially, they were saying that regularized for the highway. And now it has been converted to an application by the respondent to payability case, same and similar wages.
With the permanent employees.
Whether they are doing same and similar work as the regular employee, and if so, they will get the wages of the regular employee is provided under Rule 25. If not, they will not. they will be paying pay. So the exponent number 3, 2 is the officer designated under the rule 25. Rule 25.
Yes.
Twenty-five. Subgroup 2, Roman 4. The rates of wages payable to the worker by the contractor shall not be less than the rates prescribed under the minimum wages act 1948. For staff employment, where applicable and where the rates have been fixed by agreement, the government or award or by the appropriate government, not less than the rates so fixed. So if you have a settlement under the idea, you are supposed to pay as per that.
Settlement.
Then finally, in cases where concerned with this, in cases where the workman employed by the contractor perform the same or similar kind of work as the workman directly employed by the principal employer of the family, the wages, holiday, hours of work, and other conditions of service of the workman directly employed by the principal employer of the establishment of the state or similar kind of work. Provided that in case of any disagreement with regard to the type of work, the same shall be decided by the executive level commissioner chapter. So this is where he comes in. That's point number 2. If there is a settlement, you follow settlement. If you are doing now the exception by the, if you are doing the same regular work as the regular work, then you are entitled to get the same pay as the same wages as the regular employee. And if there is any disagreement on that, the authority will decide whether the quality is same or similar by deputy chief level commissioner. In other cases, we got pointed out that in other cases, the wage rate, holiday, hours of work, and conditions of service of the contractor shall be passed as being specified on behalf by the executive. While determining wage rate, holiday, hours of work, and conditions of service and conditions, the deputy chief level commissioner considers that as regards to wage rate, holiday, hours of work, and other conditions of service of giving similar employment. We are not concerned with that. We are concerned basically with 5A and B. Namely, whether these contract workers are doing the same and similar work of a regular employee. If so, he is entitled to get the same wages as given to the regular employee. If there is disagreement, the matter will be decided by the deputy chief. Deputy chief level commissioner. Therefore, my lord, we are concerned with this. Now, what has happened in this period, as the lordship has seen, there is no step procedure prescribed in this group as to how the deputy commissioner, the deputy chief level commissioner central will proceed in the matter to decide the crucial question as to the nature of the work, the quality of the thereof and the responsibility of the concepts of employees, all that the factors which your logic have laid down so far as the pay parity cases are concerned. Yeah. So the wage fixation is a matter which is always complicated for industrial litigation. Therefore, what you have to have basically is the version of the worker, the demands, nature of their demands, the reply of the employer, and in this case, the contractor first, and the principal employer who is the company hiring. Therefore, one would expect that there will be some amount of the proceeding where some evidence is given, some documents which are available under this act are called for, and the matter is heard by the concerned officer, who both the sides are concerned, and then he passes the law. This act itself indicates a provision of appeal, not for these, but for some other matter. There is an appellate forum, and your lordship, necessarily I request that your lordship will see the appellate authority also is invested with the power after issuing notice to hear both sides, all 40 records, and then decide. Here is a case where you are going to have a decision on a very large scale of employees having financial implications. Therefore, you have to apply the relevant case initiated by the court with regard to the pay parity, so that the mind is applied to the relevant aspect, and then he decides the matter, for which a hearing of some kind is always necessary. Here, because the officer concerned has followed a very peculiar method department. Which is almost, I have not seen anything of this kind for decision of papers. What he has done is, after getting this, he wrote letters to the company and said that, what do you say about this demand? So the company replied, the replies are there. The contractor should be hired. They don't need it. All that. And then he decides, he visits he says that I am visiting Villiers and he visits, he inspects 8 departments out of 36 departments of the company. And then he passes, he records the statements of 13 regular and 14 contract labor. And there is no question of giving any opportunity of a repetition or anything. Even the statements are not given. That is the company in some of the present, but as such, nothing has come. And then he passes this into an order, which your lordship sees at page
At page
60.
3075.
75 is the relevant portion I placed before your lordship.
Okay.
Yeah, it'll be again. Because that's really that finding at 75. My humble submission to God. Cleanses the matter. Actually, when I placed the offense connection with this matter. 75, after perusal, second paragraph. After perusal of the above statements of contract workers, permanent employees, and permanent employees. It is a fact that there is no total similarity in the job contents of both types of workmen. But it has also been established that there is similarity in the job contents of these workmen to a great extent, with a few exceptions. Now, if this is what you have arrived at, then the very basis for invoking the doctrine of same pay for same work, sanity. The condition precedent is absent if this is his finding, which it is. He says not very clearly that there is no total similarity in the job contents of both types of work. But it has also been established that there is similarity in job contents of these workmen to a great extent with a few exceptions.
So it's neither here nor there.
Neither here nor there. Your Lord is absolutely correct. And it is contrary to a judgment of the Supreme Court who state that it has to be identical in order to get the payment. So if he is recording this, then that basis for invoking the doctrine disappears on his own finding. And time to page 65 what he has done. Very interesting. Like a Parma. Page 54. That is bottom by 54.14 workers which we are having. Contract workers. This is set out. The security guard, medical attendant, and office. And so they are in. And turnover the page below. The 13 regular employees whose statements are recorded.
Yes.
Now kindly see. The grade of the person with whom he is compared. Grade A, first case. 1, 2, 3. Third block. Paramedical technician. Grade is the mentioned of that person.
No, where are you going?
Page 65 minutes.
Yes,
Likewise, the details of 13 regular employees.
yes,
Then
yes,
we get the chart.
yes,
First is the date,
yes.
then the name, then designation, and category of the employee directly employed by me. Paramedical technician, grading. Kindly note that, grading. Because as I have said, starting from grade 1, it ends at grade 9. So he is taking next particular person. And then kindly see all the others, grade 5, next one. Third one is grade 5. Fourth one is grade 7. 5 is grade 5. 6 is grade 9. 7 is grade 8. 8 is grade 5. 9 is 5. Then grade 3. Technician.
No, so what do you want to show by this?
5 is now kindly turn to the I just before lordship 3 paragraph. What is the effect of this? Because the whole
No, you see, he has taken the statements of this grade 8, grade 5, grade 9. What do you want to show by this?
compared a regular employee of this state,
Uh-huh.
a contract labor.
So according to
Now,
you, she should go to grade 1 or something like that.
They start at grade 1.
Uh-huh.
Over a period of time, when the regular employee is appointed, he goes through an open competition, selected, and then he joins as a grade 1. Then in course of time, he gets 2, 3, 4, 5, 6, 7, 8, 9, he will retire, he may not reach that. He'll reach in between. But that is his case. Now, you are comparing, if you are taking the statements of from grade 1 to 9, there is no grade 1 there. Third, fourth is the lower, others were all 5, 6, 7, 8, 9. Now you are comparing them with the corporate level. And the result is what we have indicated, and that's why I am saying that I will test 3 or 4 men. The chaos which Supreme Court in one judgment said that it is something which may lead to a chaos. Therefore, it's an expert job if you want to fix the wages of a established, more particularly of a company like this, which is engaged in, exploration of oil, where that requirement is there for employees. Because in the field, the different stages, one goes through specific statistics survey, then reading survey, and after doing all that, you may not get anything. Therefore, no company can maintain a group of laborers on a regular basis, because these are all very uncertain exploration. Nature of the business is that you strike oil somewhere, you make up for everything, but you lose heavily when ultimately at the end of all the exercises, there is no
Right.
right. It happens,
That happens because even in Mizoram state,
Yes,
they have had drilling operations in many areas. They have not struck oil in any of the places.
this oil company, I remember some years ago when they started in Rajasthan, I think all their oil drilling sites, it was proved to be dry. Even in Assam, the latest we were required to give an opinion, we found about 8, 9 explorations are going on. 3 of them dry. So it happens. It's a very uncertain sort of. And I'm trying to indicate in this paragraph, who are these persons with whom you have compared? Persons who are appointed on blue contractors, where there is no open competition, where there is no qualification prescribed, and they come to a contractor and do whatever is required to be done. Now, kindly come to paragraph 17, page 18. And these environments, as far as I can see, are not reversed. Paragraph 17 at page 18.
Page 18.
Yeah, page 18, paragraph 17.
Page 18, yes.
The petitioner company begs to state that the mere reading of the incident order will show that the respondent number 2 was totally biased against the petitioner company and accuracy has converted the first application of the union to an application of the 25 of Para Rule 71. Is that understood as to how the respondent number 6 can compare an unskilled workman's job with that of a junior engineer with a highly qualified technical person? The respondent number 6 was fully.
Why do you say junior engineer? Oh,
Page 65. That's why
page 65. Who is it? Okay. Number 3.
for example, engineer
6.
grade 9. Is the city that
Junior assistant, junior engineer. Okay, 6.
they 5.
Yes.
On the basis of what is appearing from the judgment, this is a summary to show how the entire application of mine was faulty. The basis was absolutely unknown to whatever your lordships have held on paper indication. Respondent to was fully aware oil has expanded movement from grade 1 to 9 and that an unskilled regular employee who enters into grade 1 of regular scale required around 25 years to enter into grade 9 after appearing in examination in biology for promotion to take its higher grade. Provided that agency arises in the higher grade, right, 85% were passed and obtained a apprentice certificate under the Apprentice Act or a degree from ITI. The technical qualifications are only recruited to grade 5 of the region order and safety. Accordingly, contract level cannot be equated to the workmen as has been done by responsible person while passing the order. In this regard, the petitioner begs to state that the regular employee who enters into grade 1 will growing subsidiation and biology gets a total monthly salary of 27,806 at that point of time. In comparison to the monthly salary of the WCH, who doesn't come to any such selected person, gets a monthly salary of 26,590.
Go.
In respect of step 1, whereas the step 2 and 3 has monthly salary of 25,000 and all, the step 3 as on 3970. We have given the chart of page 83 for your look. The next paragraph looks at para 18 and page 90. Then the company begs to state by the Indian order, the respondent group is trying to bring on the equal pay for equal work by comparing the work of regular employees of the company working in the same time with that of the contract laborers who are performing unskilled work. A regular security guard after getting promotion from grade 1 to grade 5 will necessarily earn more than any other regular security guard of grade 1. Accordingly, comparison of a security guard of grade 5 with a contract labor and which the contractor will have no meeting that they are in his own Indian order has indicated that the regular grade 5 security guard is responsible for the physical workmen engaged by the security agencies and contractors. So the grade 5 security guard supervisor the contractual security person. And you are comparing him with that and then increasing the salary. That is the result which has come about that basically. However, the respondent didn't take into account of the vital aspect of the matter which has dictated the entire duty and as such equal order is and without making an agreement. Second thing, the definition of the exercise similarly the response number 2 while dealing with the case of the medical activity compare the contract labor with the paramedical technician of that age, which itself amounts to comparing a highly skilled person with an unskilled workman. This is all I'm taking from page 55. So he is given the case. Technically, a paramedical technician of grade 8 is highly skilled employee recruited directly as per company who can provide all medical assistance in emergency patient, even in the absence of the doctor. However, contract labor who is working in a medical department, taking patients care and interview and doing maintenance cannot be able to perform the same similar kind of work.
Okay, basically I get the gist.
Therefore, in 1920, dealer and helper they are getting very well. And there also it is comparing with the age. We have related that it is also absolutely. Okay. English for so these categories are there to and check the evidence. The two evidences, one by responding number 3. The gentleman who passed the order is no more there. The passing of the order here is done. Case number 8, file an evidence. And respondent number 3 has also filed. The union in fact, they have filed their. And they have not rebutted all these requirements from these 3 relevant paragraphs, which are also defined at page 2 and 5.
4 paragraphs you mean. It starts from paragraph 17. So 17 to 20 not controverted.
That is being dealt with at page 87 of the affidavit of respondent number 3. Internal page 4, running page 87. In paragraph 16 and 17.
No. If it's not controverted, it's not controverted. That's all. Why should we go beyond that?
No, I'm.
Let them say if it's controverted.
There's no denial. So this is the factual position. On this pillar, my respect to submission. Yes, summarize it. First is because the effect of a settlement in consideration, the legal.
Effect of settlement.
Settlement under section 18. Second, we have read from the first, query. That the quality, the qualifications, the mode of recruitment, everything is different. Therefore,
The quality,
the qualifications, mode of recruitment, responsibility, these are the relevant steps courts have done. These are all absent. And therefore, there is no basis for pay parity. Third aspect is without any help from our first letter itself indicated that these employees are employed by the contractor first. And then we are the principal employer. The act and the rules indicate that the contractor has to maintain registry. I told you the relevant provisions and the documents which are required to be. Therefore, we said that contractor is a necessary party. And therefore, you are Then the notice to him, all body report and also getting prepared. All these are, when we responded to the letter, we mentioned the requirement at page.
Page?
I just. And also because what is needed. Principal guidance from this court as far as the exercise of power under Rule 25 is concerned. Statutory power given to the sometimes. He has to exercise, in a reasonable manner.
Under Rule 25 of what?
Of the rules, the contract, labor, regulation, and abolition. 1971. Formula contract labor, within bracket regulation and abolition. That is 1971. Some kind of a guidance is needed because if he thinks that
Why should, if the Supreme Court has passed number of orders,
they have no effect,
so why should this court pass any guidance?
indicating that might help them to understand that you see, it is not a question of between farmers. And the way he has proceeded, because I showed you paragraph, he finally, final order, but I have not shown. Right. Reporting and finding at page 75 says it is not a printing. He is now page 18. That's page 79 in the last paragraph of it is a fact that the recruitment rules of permanent employees are different compared to contract labor. For mode of recruitment is different here. So far as skill, knowledge, experience, and responsibility, accountability, initiative, liability, trustworthiness, and contract labor are concerned, it is not less than the permanent employee. Without taking nothing, he makes his own. The contract labor are working things wrong, and they have acquired sufficient skill and knowledge of the job over the years. Now, this is an irrelevant consideration. You may work for long. You may acquire experience thereby. Nobody will dispute. The question is not you get the regular place because of parts or salaries because you have worked for long and you have acquired that experience. That we assume that they have done. But even then, the test is not fulfilled. The quality work of the work, the responsibility thereof of the person concerned is different. If the mode of recruitment is different, if the disciplinary proceedings are different, because the contract labor is going to be removed by the contractor. He is not a direct employee of the principal employer. The principal employer will have the responsibility if the contractor fails to pay the wage. That is provided. And the company can deduct from its fees. But payment has to be made to office. And that liability is then default liability will come to the principal. And he can realize it from the abuse. That is the provision under the activity rule. Therefore, my lord, the same pay will not be even because the worker has worked for a long period of time. And thereby he has acquired some experience. If other factors are not present, because then he gets his own progression in the perfect scale of pay, which they are getting as I have told 3 years in basic pay has been. So it has changed, and in fact, I'll show you what is the total amount that people are taking now. Good, I am happy that perfect labor without any proper qualification is getting something which before I read in the paper, I kept the paper because I thought I had to bring it and show that what is the all India data. It was a news item concerning a central government recent data. And so what is the normal salary that a worker gets in India? And it was from 12 to 15,000. That is the state of the life. And I am happy therefore that in 2008, this company has given the basic pay of the regular, which, as your lordships know, first ultimately what has the Supreme Court said in the Justice Kehar judgment in 2017. If he is the person also has can be said to have done the similar and same work, he earns what? The minimum of the scale of the regular employees. And that was the salary which was granted in 2017. And now, following that, almost every high court is saying that you must get the minimum of it. It is not a question of getting minimum of the scale. If you satisfy this condition of same and similar work, you get the wages, everything, which are regular work. You don't give, you have said that it is not identical. You don't give some enhancement for experience or for long period of work. That is not for 25%. If he is doing the same work and similar work, he must get what the regular worker is getting. But he is not then finally trying to pay 80. After holding that page 75, it is not identical. After holding that they will get because they have acquired some experience. In view of the above, contract workers categorized as district 1, 2, and 3, engaged by All India.
I'll just cover the 5 minutes. That's what, look, he said that they may leave. So I don't think there's any chance for the other matters today. Dates will be due for. Okay. Page 80. What, Mr. Barwa?
Final now the few of the above concept of the categorized as listed 120 in this law in this by day of have been found to be performing the same and similar kind of work as of regular employees of the company for pretty long time. Hence, their monthly wages with commensurate with their volume of work, hours of work, pure and other conditions of service which are used to bring about parity in comparison to regular employees, if possible extent. As such, the wages of these contract laborers known as the WCL 1 fixed the following and he fixes because wages. Category 1 is security guard. 2 and 3 are security guard 1. Top and section all wages fixed on monthly basis 27,659 plus 5,000 32,629. Next category 2 27,629 3,000 30,629. And security guard 3 27,629. So one of problem. Then medical attendant is basically WCL 1 27,629 plus 5,000 32,029. 3,000 added to 27,000. 27,622. Cleaner and helper WCL 1 27,659 5,000. Second category 3,000 added and 27,629.
So this 27,000 is based upon
Now,
your written
where did
statement.
this come from? Kindly turn to without page 68 and 69. Page 8, irregular employee. Grade 1. $27,629. He first takes this total of the amount of the grade 1. And then he gives his own heading 5, 3, and in one case there is nothing. This is because he
Use 5 and 3, 5,000, 3,000.
that is
No, this is for the regular tradesman and attendant or what? This page 58,
850 regular.
regular.
Regular. Normal open recruitment. Areas of 1970. 17.
Now this
Total amount they are drawing was 27,620.
So 5993. No, so this tradesman is the pay scale of a tradesman, regular tradesman, security officer, medical and cleaner helper, all the same. It starts, all of them start with 27,629. Yes, grade one it was same. So 27,629 at that time was its super wage. Super regular, grade one employee. And page 59. On date means that was in 1970. This is the list of contractual employees, 1, 2, and 3. And they were getting totally 26, 597, 96. Each two is 25,560, 565, 12. And third, 15,998, 58. So they're getting much less. So this listed three. These are the contract employees or the contractor employees? This is the chart for the contractor, 617. So instead one was getting 26,597, instead two, 25,565, and three is 16,900. Now, if your lordship kindly turn, therefore, to page 80. So 27,629. Takes it from page 58. Yeah. Then he has his own amount, 5,000, 3,000, and 27,629. Is the three. He is giving from 16,900, 998 to 27,629. It's a increase of about 10%. And he doesn't give any reason why he is giving this 5,000, 3,000, and 10,000 is involved in the third category, because they were earlier looking at page 59, 60,998.58%. And he is now making it 27,620. 81 page 5,000, 3,000. And therefore 5,000, 3,000, and 27. So this is his method of, drawing, imprinting the pay and drawing. How we not increase it. So after recording two contradictory findings, one saying not identical, then you have required some experience in this and not for long. Therefore, which is something.
Now, look. Page 121. Just kindly turn to page 134 for a moment. Meanwhile, Miller, these settlements situation was over for which we therefore finally below the 9/11/22 130 page 136. Because this is the current certainly not about the signed by 16 9/11/22 page 136 1. Your option is there, but before that, we look at page 134. There is a chart been prepared. I show this first. The effect of 22 agreement also is reflected in the
So the latest MOS is dated?
9/11/22. At page 136 is current. 136, 142. The motto wanted the benefit of this is the current.
Okay.
That clause is there, I am sure you will. That you must, that undertaking that you are accepting the clause. The numbers of that agreement was not doing that, therefore they are not getting it. So, try to have a look at page.
They could have come directly to you. They did not go to them also.
Accept the right procedure. Design or importantly, the letter.
I think I think they can go to either. They don't have to go to them first also or to you. They can come directly to you, sign the undertaking, that's the end of the matter. Only thing is that whether they are part of the union, that is the different issue.
If they don't want to be a member, there is no part in their design. So they can resign and then give a letter to them that we are giving this undertaking fair. Now, kindly see at page 134. The difference in summary. His 2017 position is the first start and the second start. First is before the order to give first charge. You were getting instead 126,597. 625,500.
Yes,
That is before the impugned order.
before impugned order.
Structure of interest survey as on 1/7/17. Then wages of interest survey here for order dated 21/9/17. March 2023 is given.
So it is after impugned order.
After. So. 27,629 is the common denomination. And the additional component is 5,000, 1,000. So they get now 32,009, 30,629, and we start the It is the effect of the on. Now, with the structure of instead of the sales as on 1/1/20. That is after giving effect the. because
So
that was-
no, just tell me, this memorandum of settlement was made on 9/11/22. Was it given a retrospective effect? If it is not given retrospective effect,
Here. Page 141. Of 14. For arriving at a single settlement, the duration of the settlement and the increases on a proof. Now,
Okay.
here listed one.
so it has come,
Listed-
one listed one, it is
now
from one.
listed one,
Okay,
that is the 1, 2, 3.
has gone.
Listed one with effect from 1/1/20. That is the effect 31 year.
Then what about the B?
With effect from 1/7/22. 31/12/32.
So 2 and 3 still remain. 2 and 3 still remain. Yeah,
Settlement of 9/11. Which concern instead of listed WCL 1/1/20. Which is from 1/1/20. This is the current position.
but that is not in conformity with page 141.
141. Because
Para 14B,
settlement fee from 1/7/22. 31/12/32.
32. And then,
The earlier one is 1/20, 1/1/20, 31.
no, because you said after this, the latest MOS, to the listed 2 and 3 they were no longer in existence. Only listed 1 is there.
All of them have been combined. That's what I'm.
Since when?
To the
How do you say that? How do you come to that when the settlement speaks of 1, 2, and 3 being in existence till 32?
from 32, it will be 1. Fourth. So it will expire on 32, just 31 till 31. 30. After that, it will be only 1 minute.
Anyway, so that is not an issue now. Then
No, but yes, of the latest settlement, your lordship study every 130. Page 150.
132, yes.
Rate structure of listed WCLs with effect from 1/1/23.
WCLs, all.
Or
How do you come to this figure? How what is the basis? Who has made this chart in the first place?
we have been.
How do you come to this magic figure?
9/11/22. Instead of page 129. But 129. With structure of listed WCLs as on 1/1/20. Page 129.
129, yes.
For those who have not signed the MOU, latest MOU, page 120. They are getting, 39,943. Might be,
Why should they get, who has made this pay for them? On what basis? Because you're complaining about the pay being given and you're giving them a higher pay. I don't understand.
because presently received by officials who have not signed the MOS 911. So those who have not signed, they are getting 39,943. Now, your lordship, see that figure at page 134. Where your lordship gets one chart. Last chart. Which structure of listed surveyors as on 1/1/20. 39,943. This is what they are getting, namely those who are part of this litigation and members of the queue. So they are getting 39,943. If Miller, they were to sign this, what they would get, that is Miller 46,004. 130. Can you start?
I'm getting lost.
Because we are, I think they're giving two different.
Who is giving charge? So the company is giving two different charge. So you have got to then decide which chart are you going to follow.
What are in force? 39,943 or 43, that page 134. Is the chart after the latest settlement, to those members who have not signed the, given the other, as required under the 22.
So those persons who have not signed the undertaking
They
are being given as per 134.
They have not given the undertaking which is required under 9/11/2018. That you give an undertaking accepting all the terms. That they have not given.
And those who are accepting the MOU, they are given as per 132.
That's right. 46,000.
Is it correct?
Yes. I have also after instruction, I have written the. It's 39,943.32. Present of officials who have not signed the new MOS. If they sign, they get it. That's page 132. That is concern after sign. So they are losing for not signing the settlement by 7,000 rupees every month. This is 39,948.
But how much is the regular employee getting?
This is of this figure. 46,254.
If the regular employees are getting 46,254. No, I don't think so. No. Your case is that
Regular employees are distributed in 9 days.
correct. What is the lowest grade getting? What is the lowest grade getting? Because the grade one, it's the same whether you're a medical or you're a attendant, same.
131. 40,000. Regular employee of oil in grade one, first grade, 40,994.
So,
Regular employee,
so regular employees getting less than,
40,994.
is getting less than the MOS. Is it? Then what is the fight all about? Why do they want to get a lesser pay?
So this is, the difference is 131 is the grade one,
Correct,
Ah.
correct.
40,994.
Regular,
And
for regular employees,
130. Contract labor will get 46,254 if they sign the. If they undertake.
correct. No, so, but page 131 shows that regular employees grade one, they get it 40,000. Now, if they can get, if someone can get 46 by signing the undertaking, what is the fight? Why should they want to fight for a lower pay scale?
But we have, I have found somewhere where we are saying that if a regular person going through all the competition joins in grade one, he will draw less than the contractor.
Correct.
That is the situation.
Now from, why should now?
But ultimately, your lordship will have to decide whether the respondent number two was correct in holding that they are doing the same and similar work. That's about all. Wage wise,
No,
the total wage, if you go by total wage, as of
no,
now,
no, it's,
they are denying us the date given by the deputy chair from 2017.
deputy CL, what is deputy CL?
Deputy. That is respondent number two.
They are denying you the rate, the pass arrears.
Failure.
So you are fighting for arrears.
No, they don't want to give up. No, they are giving this 46,000, they want that 5,000 more, 3,000 more, 10,000. 2017 to 2000 have only words. That they don't like to give up. No, we are giving as far as, because we are not giving, but as they are like, the column number two, we is issuing 5,000, 3,000, and in the third category, 10,000.
You see, the thing is that
That's why.
as after the latest MOS, the contractual employee who accepts the MOS will be getting a higher pay scale than a regular employee
From 2022.
from whatever date. So now, I don't think y'all are praying for getting a regular pay scale because that will be lower than what a contractual laborer would be getting. So what is the fight all about? Is it because of arrears that you did not get as per the Deputy Chief Labor Commissioner? That is your case.
They want both. The effect of 22 settlement is 46,000 plus the one given by.
Okay, so they want 46,000 plus the earlier,
3,000 and.
which they have not been getting since, from which period to which period?
2017 to 2002.
2000. Okay, fine. How much were you getting that time?
That time. 26,597. Page 1.
Okay, so that we are fighting for that 5,000 and 3,000 basically.
Yes, they're right. 5,000, 3,000, 10,000.
Ha, 5,000. 5,000, 3,000, 10,000. Okay, okay.
So, what?
So that's so we are basically on the issue we are basically the dispute is with regard to the Deputy Labor Commissioner award enhancing your scale of pay till the time the 2022 memorandum of settlement came into effect. It is for that period.
Regularly, unity getting, they paid 134. They are getting now 39,000 and all. Because they are not signing. If they sign, they will get 46,054, is 132. In that case, we have to give up that area. What area?
No, but okay, one thing, the Deputy Chief Labor Commissioner's award, I mean, that pay scale that he has made, that to be given to the contract laborers, that has not been followed by you. That is because it has been put to challenge. It's state by itself. So only thing is, but you have followed everything. No, you have been giving them the 27,000. So that you have given.
39,000 they are getting now.
No, as earlier. After the Deputy Chief Labor Commissioner's award with regard to parity of pay scales, that was not followed at all. How much were they getting that time prior to the award? That was as per whatever. Less than 27,000 basically. Less than okay. Yeah. 100. Huh? 26,231.
No, 134.
Anyway, less than the amount awarded.
56,000. Before the.
Okay, so the issue is on the issue basically now is that only. It's only with regard to that period for the arrears. No, the issue according to them is that.
No. He has been invested with power not to decide on arrears. The authority is.
No. He is not deciding on arrears. He has decided that a certain amount should be paid, which you have put to challenge here.
Yeah.
But their case is that award should be implemented. That's all.
That proceeding is under 25(5)(a). Namely, whether they are doing the same and similar work.
Correct. No.
And if there
Correct.
is disagreement with regard to that, the officer, deputy chief, labor commissioner is invested with the power to mediate.
Correct.
So it is not that they are asking for the only area. They are saying that give us the same scale as the regular. Same wages as the regular.
No, but then that will only be up till the memorandum of settlement of 22, because memorandum of settlement provides that the contract laborers will get more than a regular employee, as per page 131.
Because that is the anomalous situation which has come about.
Yes, but then that is what they're going to do. That is what they're
That is
doing.
why your lordship will have to examine.
No, that we'll examine. We'll examine all aspects. But I just want to know the issue.
Why the amount which they are getting, whether it's a
Kalpana,
reasonable amount.
what is Anupam doing? He's got a lot of correction. He's got work. Let over no work. Tell him to come. You've got a lot of work. You're finished. Then tell him to come. You have not finished, no? Then you do, you've got a lot of work.
So, UPT demand now.
Huh?
UPT demand. You were saying, what is their demand? That we are doing the same work. You will give us the same pay. Right? He has said that it's not identical work.
No, no, that, all those issues are there.
He still gives them something which is not legal, because his own finding negatives the application of the disability rule. Therefore, settlements which are coming in 22 gives them a better structure of pay than the earlier settlement, which comes to, if they sign, 46,254. They are not signing some of them, therefore they are getting 39,943. But it can't be a position that you are getting this amount because of what?
No, no, I understood your point. I understood what you're trying to say. But now I'm also understanding what they're going to say.
They are saying that means
I'm not saying whether they're correct or wrong. I'm just saying I'm understanding what they're trying to say.
I'm trying to also explain
Yes.
that the crux of the matter is different.
Yes, according to you, the crux of the matter is whether that the deputy labor commissioner could have passed the award in the manner it has been done. That's all. That's your case. Huh. Now, yes. And his case and their case is whether their case is that as the deputy labor commissioner has passed the award, which is correct, we should be given that. And as and when that memorandum of 22 takes effect, we should be given the benefit of the memorandum. That's all. Because that is now higher than the regular pay scale of the regular employee.
That would be an irrelevant position.
Correct. But that is what they want. So that is what is happening is you all want the regular pay scale, but when it suits you, you don't want it.
That is because of the
Memorandum of settlement.
It's a combination of both they want. The act itself,
Huh?
the act finding is they're not identical.
No, those issues I will look at it. I just want to understand.
If you what is it right? So it leads to the anomalous position that a qualified person going to an open competition, joining in grade 1 will get less than the contract labor in grade 1 after the settlement.
No, that is one point. The other point is you're wanting the pay scale given to a regular employee up to a certain period only. After that, you want to be given the pay scale given to a contractual employee in terms of the settlement made in 22.
The both can't exist.
You want to eat your cake, have your cake and eat it too.
Because the law permits.
No, we'll hear you on that. And this is what the general, the vague concept that is coming in.
Result of what has happened after the audit. You have to give effect to it. And that's why Supreme Court is also cases said that it leads to a chaotic situation sometimes. This is a very appropriate example of that. And finding qualified then open competition joining then someone who has not their qualification is not to that open competition. And will be working further. It's an anomalous situation. lord, if you go by the amount only, I can tell you lordship, that's why I. But all India figure was given, it was built to 3,000.
No, that's okay because,
Assam, I don't think anybody, any contractual labor in any industry is getting what they are getting. I don't think.
no, you see, even in this legal services authority, for office assistants who knows computer, in the cities, they're getting 15,000 a month. And for in the small towns, they're getting 12,000 a month. Huh?
Yes,
Industry?
industry company here, then very fixation order and follow Supreme Court has laid down right from 30th decision, just to that case, that very fixing is a very complicated affair. Therefore, you must follow region, some figure. That's the general basis.
Anyway,
And even 25, 5 states there. The deputy commissioner or deputy chief language officer will have regard to the relevant aspect, which includes the amount which is being paid in the region. That also is there. That has to be there. No? In a place like some, I don't think there is any industry which pays contractual labor the way they are being paid. It's good they are being paid this way. I am not saying they should not be paid, but we see the general situation. That's why I was saying that it's a government of India report. That I really copy it. I don't know where it kept it, but it said it is from 12 to 15.
okay. Anyway, let me give some notes to him. Otherwise, you're not going to finish. And Mr. Das has not even started. And Mr. B.D. Das is there waiting in the wings also. So just let me write, I'll give a, how long will you take for your, how much? Finish.
Almost. It's a big expression from the.
I know. It's like the,
That's more, and then I bought the pages. Yep, and I give it. I think it's a principle.
okay, tell me. Okay, you're not finished, no? We'll go back. You go back and I'll call you. Or are you going to continue or what? Well, I've got a lot of problem because I've got a lot of orders to sign and pass. And some are very, this bench is very urgent. Some have to, some have to, some have to go with the order to the to the thing, to the authority. Huh? Kalpana's matter, that is that. No, he's got also something. You got any matter? Urgent, very urgent. Kalpana has got, no?
Based on your lordship and I.
What is okay, right. The petitioner's counsel submit. No, the petitioner's case is that. The petitioner's further case is that. Some guidelines have to be laid down. For the Deputy Chief Labor Commissioner, bracket Central, huh? Hereinafter referred to as the DCLC, bracket C, huh? To come to a finding as to the rates of wages to be made payable to the workmen by the contractor, which would be the minimum of the pay scale given to a regular employee. Combine as much as the 1970 Act does not lay down the procedure or the guidelines to be followed for coming to a set decision with respect to fixation of pay. Full stop. The next para, the petitioner's grievance is that the deputy chief DCLC had not recorded any evidence to come to a finding with regard to the minimum wages payable to WCL listed 1, 2, and 3, and had instead based his decision by visiting 8 out of 36 departments, 36 departments in the establishment of the Oil India Limited. Further, he had recorded statements of 14 contract laborers and 13 regular employees without giving any opportunity to the petitioner to cross-examine the said persons who are examined by the DLC. The DLC had in his order dated, DCLC whatever, in his order dated, what is this date? Order dated 11/9/2017, issued passed under Rule 25 bracket 2 bracket Roman 5 bracket capital A and capital B of the CL of the 1971 rules. Had examined contract workers who were in the grade of 1 to 3. So on the other hand, he had examined the regular employees who were in the grade of 3, no, grade of 3, 5, 8, 9, and 10. No, no, not 10, 10, 10 is okay. 9, huh? 9. Roman 9, huh? Thus, no, full stop. When there were 9 grades of workmen in the Indian Oil Limited, in the Oil India Limited, the DLC, the DCLC could not have what? Could not have, wait, that is in para 17. Could not have compared an unskilled contractual workman's job whose grade was lower than the job of a regular employee who was of a higher grade and was more qualified Yes, sir. Then you take this para 17 to 8, 17 to 20 of the writ petition, huh? Page 18, 19, 20. Huh? Next para. The DLC, the DCLC had come to a finding that there was no total similarity in the job contents of both types of workmen, that is contract workers and permanent employees, in the impugned order dated so, huh? Dated 11/9/17. Full stop. However, it had also been established that there was similarity in the job contents of the workmen to a great extent, with a few exceptions. Full stop. The petitioner questions, the petitioner's counsel questions the basis for the DCLC to have come to the above finding. Further, when the DCLC had come to a finding that there was no total similarity in the job contents of both types of workmen, the very basis for grant of pay parity was lost. As such, pay parity could not have been given by the DCLC. In this respect, he has relied upon page 75, Page 75, blue to blue, okay? 75, 76. Next paragraph. The further case of the petitioner is that for appointment of regular employees, an open selection process is applied, wherein the selection is made on merit. However, for contract employees, no selection process is followed by the Oil India Limited, as the contractual employees are provided by the manpower contractor. Next paragraph. The petitioners for the cases that as per section 7 of the 1970 Act, registration of establishments are required for what is this for? Registration of establishment? What happens? So once you register yourself, then what happens? Okay, to the contractor. Okay, what have I said? 7, not 75, 7. 7 of the 1970 Act. Huh? Section 7 and 9 of the 1970 Act, comma. No, the principal employer is required to register himself, register itself for employment of contract laborers in the establishment through contract, no, through manpower contractors, correct? Labor contractors, through labor contract. Anyway, these are not issues anyway. Next. The petitioners further case is that the contractor is a necessary party in this case. The labor contractor is a necessary party in this case. However, he has not been made a party. Further, no, next para. The wages of the contract laborers had been settled initially through a memorandum of settlement dated memorandum of settlement dated 11/8/2010, which was in respect of WCL listed one employees. Which was valid from 1/1/2010 to 31/12/2019. Thereafter, the second memorandum of settlement dated 28/5/2013 was made was made effective. No, which was with respect to WCL listed 2 and listed 3 employees was made effective with effect from 1/7/2012 to 30/6/2022. Next paragraph. The impugned order of the DCLC dated dated 11/9/2017 which is put to challenge in the present writ petition, had fixed the wages of the work of the contractual employees in terms of the minimum pay scale given to grade 1 regular employees of the Oil India Limited. First off, however, where is that chart? Huh? The chart where he has put 5,000, 3,000. Page 80. What do I said? However, the DCLC had added rupees 5,000 on the minimum wages payable to WCL1 as follows: 27,629. No, as follows, WCL1, WCL2 and WCL3 as follows. You just take this chart at page 80, 81. Next one. Subsequent to the above, a memorandum of settlement dated 9/11/2022 was executed between the petitioner and six unions. The latest MOS, 6 union. Which was to be valid in terms of clause 14, which is as follows. Page 141 in red. It is here. Okay. Next one. The petitioner's counsel submits, next para, that the members of the respondent number 3 union are at present, submit that the wage structure of the listed WCLs, that is the members of the respondent number 3 union, as on 01/01/2022 is as follows. Okay. That is at page 134. In blue, actually. There are 3 charts, the blue one. He also submits that, next para. The petitioner's counsel submits that the wage structure of the regular employee of Oil India Limited who have joined as grade 1 on 20/12/2022 is as follows. Page 135. Okay. Next para, you're right. The petitioner's counsel submits that the wage structure of the listed WCLs with effect from the WCL grade 1 or what? Page 132. Grade 1. One 32. Acha, it's for contract. But if I said the wage structure of, but you have said listed WCL. That's what. No. I said this for the contract. Wage structure of the listed WCL with effect from 1/1/23 is as follows. Page 132. Okay. Who are getting saved? Correct. And this grade 1 regular, they're getting 40/99. Next paragraph. The petitioner's counsel submits that the contractual laborers, the contractual workmen are now getting the contractual workmen grade 1 who have opted for the memorandum of settlement dated 9/11/22 and now getting rupees 254.76 per month, while the regular grade 1 employees are getting 40,994.40. Pusta. The members of the respondent number 3 who are getting 39,943.32 per month are on the one hand claiming parity of pay scales as per as given to parity of pay scales with that of the regular employees grade 1, and on the other hand opting for the wage structure of the contractual employees given pursuant to the memorandum of settlement dated 9/11/2022, as the same is a higher amount. This has led to an anomalous situation, and the same cannot be allowed, as it amounts to the members of the respondent number 3 association trying to have their cake and eating it. Trying to have their cake, Flurries ka cake, and eating it too. Full stop. Next paragraph. The stand of the respondent number 3, on the other hand, is that they are to be given the wage, they are to be given the wages and other benefits to bring about pay parity with the regular employees in terms of the impugned order dated 11/9/2017 passed by the DCLC. For the period from 11/9/2017 till the time of issuance of the memorandum of settlement dated 9/11/2022. Full stop. Thereafter, the members of the respondent number 3 should be given their pay structure as provided to contractual employees in terms of the memorandum of settlement dated 9/11/2020. Correct? I mean, I'm just writing it down. You can, just for my understanding. Okay, we'll close, huh? Then just write, then that is just for my notes. Huh? I don't know how long I'll be out. It was good we are going away. Next week. Next week I'm not here. Huh? Will be helpful. That's why I'm making a note. On matter, you always immediately he will dictate the good getting up to the bed. So we'll list it after 2 weeks. Because 1 week I'm not here, that's for 100% I'm sure.
Either on Tuesday or Thursday, whatever.
So Mr.
And will be better, in fact, it's better, that is.
Okay, right. This is the matter. After 2 weeks, just in case. No. Huh? Just in case, because I do not know, 1 week though I'm away, I know, that much I know. I do not know if I'll be put, because usually we are sent for 2 weeks. So, I might be away for 2 weeks. So this is the matter on second, 17th. Or instead of 17th, to make it, I think, 19th. At 2 o'clock. At 2 p.m. Here they go.
Well, can it be given at 2 o'clock?
That's what I said.
That is better. That is better.
It's already parted. I've already put it. Unfortunately for me.
Fortunate for us.
No, might not be, because see, I'm out, when it will be out of station. You've got to wait.
No, that is part of the game. There is no problem.
Anyway, okay.